The addition please. First, there will be submissions through VC regarding any adjournments. After the VC submissions, will be moved from left to right. After the any submissions will be done. Display board work करते रहे.
Sir?
Chakravarti sir, is it clear? Is
Sir, it's clear, sir. Sir, you are giving adjournment, sir? Sir, court officer, sir?
Sir, I am not giving the adjournments. Submissions with regard to adjournments will be made first through VC, followed by memo submissions and submissions in the court hall.
Sir, third time office objection is there, lordship has directed, sir.
And
Anything?
please don't take any adjournments in office objection matters.
We'll complete today itself, sir.
When the matter is called out, make submissions, sir. Any mentioning through video?
Your Lordship, this is Muhammad Abdul Qayyum, Your Lordship.
Yes.
A review petition was filed against an appeal. Your Lordship, Railway Claims Tribunal claim was allowed, Your Lordship, allowing 4 lakhs. That should have been 8 lakhs. And a review petition filed, it is not posted. It may kindly be posted, Your Lordship. Memo is filed.
When is the memo filed?
Memo was filed in 22nd March 2022, Your Lordship. They have
That was
taken
not before our roster. That was before previous roster.
previous roster in Kalburgi bench. But Your Lordship has to review this. The claimants did not receive any compensation from 2011.
It requires some details. Mere oral submission through video conference
File is
would
in
say the
Bangalore.
registry into difficulty to trace the memo.
File is in the regional office. File is in Bangalore only, Your Lordship. Memo is also moved. Memo
Repeat
is
the
sent.
number for code. Repeat the number, please.
RP number 200,029 of 2022.
Put in the register, let them find out. Register would find it out. Yes.
Myself.
Any other mentioning?
8th June,
Yes.
I said. Any date.
Memos.
Responding.
No urgency. File it in the registry. Necessary application. They will list it. Yes.
The claimant,
What is the nature of the suit and which year the RFA is? Whom you appear for? Respondent. It's week afternoon. Yes.
IA is pending. 2021 ಅಲ್ಲಿ file ಮಾಡಿದ್ವಿ.
ಯಾವ ಫೈಲ್ ಮಾಡಿದ್ದು
2021
ಏನ್ರಿ 2 ವರ್ಷ ಆದ್ರೂ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ ಮಾಡಿದೆ ಟ್ಯೂಸ್ಡೇ
appellant challenge the judgment and degree passed by the High Court. For vacate the suit property within 3 months is a suit for declaration possession. Stay application is going. Officer also complaints ಮಾಡಿದ್ವಿ.
Yes. What the matter is about, whom you appear for, and what is the urgency? What the matter is about? What is the urgency? Whether the death of the appellant was brought on record. Yes.
State for us for the past 10 years, permanent injunction of granted in our favor. Here they have got the temporary injunction, for vacating stay. So they're
The permanent injunction was in force till they got the temporary injunction.
here
Yes.
they got
Ah,
their right to consult, our
yes. Next week. Yes.
IA for what? IA is for what really? IA ಯಾವ್ದಕ್ಕೆ ಹಾಕಿದ್ದೀರಿ? IA for dismissal? No. You are not entitled to, eligible to move. Yes, call the cases.
Non-compliance of office objection, second time, serial number 1, Manjunatha H8.
This matter is connected with serial number 75. Both appeals have been filed by challenging the judgment and degree passed in minutes of 11 of 13 and 12 of. That appeal is no objections regarding the petition. This office has raised the objections regarding the petition. Period. But these appeals earlier filed appeal against this judgment before district court.
In one appeal, there is no objection regarding the limitation, doesn't mean that there cannot be a similar objection.
Similar appeals may not, similar two appeals has been filed before district court, Madhugiri. For want of jurisdiction, I withdraw that appeals and.
There still delay can be caused. Still delay can be caused. Yes. The request of the Learned Counsel for the appellant. Heard the submission of Learned Counsel for the appellant regarding office objection. Where is the office objection? Next line, office objection on IS sustains. The request of the Learned Counsel for the appellant, a week's time is granted as finally to comply office objection. Yes.
Serial number 2, Chennai Reddy.
DD 21-6 in the meantime to comply of this objection pending. Yes.
Serial number 3, Jagdish Patil.
None appeared for appellant as finally week's time is granted to comply of this objection.
Serial number 4, Muniraju S.
ಇದರಲ್ಲಿ ಎಲ್ಲದರಲ್ಲಿಯೂ ಅದನ್ನು ಕೊಡಿ ಅಂತ ಒಂದು ಲಕ್ಷ ಸತ್ಯ ಹೇಳಿದ್ದೇನೆ. None appear for appellant either physically or through video conference. Counsel for K-Wait or is present. Matter is passed through. Yes.
Third time non-compliance, serial number 5. Arun Ashok Gadak, Roshan M.
Appear for appellant either physically or video conference. It's all on second opportunities of not that 3 times. The appellant has not complied of this objection. So the appeal could have been dismissed for non-prosecution. However, in the best interest of justice, as a last opportunity, 1 week time is granted. But with imposing a cost of ₹500 payable by the appellant to the Lease Committee of this court. A day from today and filing a complaints memo along with version receipt to that effect in the registry within the said time. Failing to pay cost and complaints of office subjection within the time granted would lead to appropriate order, including the dismissal of the appeal for complaints of office subjection. Case if the office subjections are not complained in total after paying the cost, registry to list this matter on 16/6. Yes.
Serial number 6, Kiran Kumar P. Serial number 7, Sitaram PK.
PB 21/6. Meantime to comply of the subject.
Serial number 8, Nehru P.
The request of the 11th counsel for the appellant. The last opportunity, a week's time is granted to complete, failing which the court will proceed to pass appropriate order. Including dismissal of the appeal for non-compliance. In case if the office subjections are not complied in time, it is issued to this matter on 19/6. Yes.
Serial number 9, Harish Kumar.
Because of the microphone, please.
Objection has been complained. Even after this, there is some objection. But after that,
The counsel for the appellant who is physically present submits that they have complied all of his objection raised by the registry. Earlier, however, after complaints of office objection, the registry has raised a fresh set of office objection. As such, it requires some more time to comply the same. Next line, a perusal of the order sheet would go to show that the said submission made by the learned counsel for the appellant is actually correct, and office objection yet to be completed serial number 1 and 2 were already there earlier and has not been complied. Hence, imposing a cost of ₹500 payable by the appellant to the Legal Services Committee of this court within a day from today and filing, etc., as a final last opportunity. 1 week time. If not complied, appropriate order, etc. Not list 16/6. Yes.
Serial number 10, Harish Kumar.
Serial 8 to the
Silver,
At the request of law counsel for the appellant, as a last opportunity, a week's time is granted to comply with office objections, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance. In case office, if office objections are not complied with.
Late,
time-
1 week last month.
Around 19.
Silver 11, VJ Benjamin.
Respondent. Yeah, I think for a suit project. Yeah, we taken possession. Use submission, I filed a memo, this, the Mazar copy also. Also tried to serve a copy to the appellant's counsel, but the RPD cover has returned as this.
Whom you appear for?
Appearing for the David respondent.
Hmm.
RFA arising out of the suit project.
Hmm.
They have already taken possession of this scheduled property.
Hmm.
And on the previous occasion, the lordship had directed me to serve a copy to the appellant's counsel with the spot measure, wherein I tried to serve the copy, but the acknowledgement as the cover has returned as accuracy left. Already taken possession, and I've filed a memo on. Filed a memo on 31/5 on the spot measure. The possession has already been delivered to us.
Counsel for the appellant, representing the counsel for the K-Waiter is physically present and submits that K-Waiter has already taken the vacant possession of the social property by executing the decree. Challenge. This is submission, the appeal does not arrive, does not survive for consideration. Also submits that he made an attempt to serve the copy of intimation to the learned counsel for the appellant about taking the possession of the suit property. However, the counsel for the appellant has not received the total of the consent to him. Next slide. There is a law order sheet to show that in this till of the year 2020, sufficient opportunities of not less than 3 times already been granted to the appellant to comply with the subjection. But 5/5/2022, this court has made the following observation. In spite of the above, since the appellant is neither showing interest to appear and make submission and to show reason for non-compliance of subjection, nor complied with the office subjection, the appeal stands a dismissal for non-prosecution as well as for non-compliance of office subjection. Yes.
Hanumanth
For
Reddy.
my lord, for appellant, my lord, objections are complied, my lord. Lord,
Alleged delayed filing of the submission of the counsel for the appellant who is appearing through video conference. Alleged delayed filing of voice violation slip is accepted. In view of
much obliged.
fact that the learned counsel for the appellant submits that By virtue of the valuation, the appeal lies before the division bench, and the registry also has made a mention in that regard in the order sheet. The registry is permitted to post the matter before the appropriate division bench. However, after obtaining necessary permission required, if any, by the Honorable Chief Justice of this matter be listed before the division bench on 21. Yes.
Number 13, Balakrishna A.
For the applicant who is physically present once again pays for each time to comply of the subsection. Considering the observation made on the previous date of the hearing, though the appeal could have been dismissed for non-prosecution, however, in the best interest of justice, a week's time is paid is granted as a final last opportunity, but by imposing a cost of ₹500 payable by the appellant to the Legal Services Committee of this court within a day from today, Mundindala filing, etc., etc. Not complied, done, etc. List the matter on 19/6. Yes, last chance 1 week. Got it.
Number 14, Mahendra Gowda CR.
Yes.
Number 15, Manjula Devi MG.
My lord, I am for the appearing for the petitioner, my lord. A week's time may kindly be granted, my lord. I will comply the office objections. Papers are ready. The petitioner is bedridden, my lord. 3-4 days time may kindly be granted, my lord. Within 2 days, my lord, papers are ready. I will stitch it today.
Yes.
Number 16, S.A. Sudhindra.
Suit for partition, but the officers raised that need to pay the equivalent court fee of the entire as a reservation. Page number 16.
What is the office objection you are required to comply with?
File the suit.
What is the office objection you are required to comply with?
Comply only regard to the validity.
What is the office objection you are required to comply with? Tell me the office objection. Required to file a fresh valuation slip. Of the 11th counsel for the appellant. The panel of opportunity each time is granted to comply while reiterating the observation made on 25/5/2023. In case if complaint is not done, registry to push the matter on 21/6. Yes.
Number 17, Venkateswamy A. Number 18, Avinash PC. Number 19, Sumati S.
Same order.
Bill number 20, Rajendra MS.
Same order.
Number 21, Shankar MB.
Same order. 20. C.
Number 22, Unnata MU.
When have you done? When you have complete 29, 29 or 30 of what?
Three or four complaints. There are three.
When you have complaint, date
16.
1, 1, 6. The concept for the applicant who is physically present submits that on 1/6/2023 he has complied his objections. Till the registry has repeated all the 4 office objections which were already published prior to 25/5/2023. In the light of the above, the registry to verify as to whether the office objections are complied with. If the registry has repeated the office objection despite its complaints, learned registrar judicial to submit his written submission in that regard. Okay. Learned counsel for the appellant. Other submit that he has also paid the court fee. Was also one of the office objection. This the matter. 13/6.
Bill number 23, Sukanya ST.
Period 21. Fine, ultimate chance one.
Bill number 24, yes, Prasanna Kumar.
to 5.
Bill number 25, Janardhan G.
For appellant money.
15 2 days will go compared to.
Ultimate chance 1 week. Period 21.
Number 26, Rakir TMC.
What needful you were required to do?
Also required by the affidavit and pay the cost of.
When did you file the affidavit?
It's filed on 26/5.
The counsel for the appellant who is physically present. Subset has completed all of his objections and also has filed affidavit, though with some delay. Next line. There is a delay in filing the affidavit as per the direction dated 24/4/2021 stands under. It is to verify and proceed further.
Number 27, Fires of BG. Here for appendix.
Good one. Ultimate chance.
28. Rajita Anaya.
Goodbye.
Number 29. Andarappa. Gurappa. Each time for this.
Ultimate chance 1 week.
Number 30, M. Narayanappa. Number 31, Pathabi. Number 32, Tata GS.
Ultimate chance 1 week.
Number 33, VB Shivkumar. Number 34, Venkata Churam.
Serial 5 19/6.
Number 35, MM Ashoka.
What do you want? For government is fiscally present. Such a memo. Submits that. Past idea of failing this appeal and the legal representatives are not interested to prosecute this appeal. With this, he placed to dismiss the appeal as a. Remove the memo for the submission. Also, the complaints of office objection and non-prosecution. Appeal stands dismissed for non-prosecution, non-complaints, and further abated. Yes.
36, MS Rajendra.
Thirty-four.
Vasant Kumar.
So quite a memo in not arranged the in number 7.
Have you complied office objection?
That was by regarding or not mentioning the different number 57.
1 minute. Some of the office objections that were raised by the registered earliest are still pending, not complied.
There was one, there's a page of the 47A, will complain about it. And the correction in the cost data, ranking of the parties, that has also been done. And there one more clarification regarding non-mentioning of the different number 7. For that, I have given a memo. The reason behind is that the judgment, there is no party name and absolutely no mention of any details. As being the no mention of any names, I am not arriving as a party name.
I am granting you 1 week time as an ultimate chance to comply the old office objections, which you submitted that you have complied, but still there are office objections to comply. And what you mentioned, the office objections, they are not the office objections which are still due. There are other office objections, but by imposing a cost of ₹500 payable by you during the course of the day to Legal Services Committee of this court and filing a complaints memo with the receipt in the registry to that effect in the day. Serial 9. Yes.
Number 38, Ramu K.
34.
Are Devanand?
For appellant not present, counsel for David are present. 34. Yes.
What? Sachin BS?
Then here. We have physically or video conference. There's a memo of retirement filed by the council for allowing council for the appellant to date 6/8/2020. Since the memo of retirement is unaccompanied with the copy of the notice that have been sent to. Accompanied with the notice. Given to the any or acknowledgement by the appellant for having collected a notice of Nama and receiving back all the papers, the memo of retirement cannot be accepted as such the same stands rejected. In of the fact that despite granting several sufficient opportunities of not less than 3 times, since the appellant has not complied with the office objection, the bill stands for dismissal for non-prosecution as well as for non-compliance of office objection.
Number 41, Shivamurthy AR.
Appearing for appellant. We have completed our complaint. We have to complete.
Can cost be imposed for non-complying one most simplest office objection?
This respondent have to complain about it. We have complained. They have filed a caveat petition. In that caveat petition, they have filed an affidavit supporting caveat petition. That affidavit is not sworn in. Sworn in, that affidavit has been, that objection has been raised by the
Office subjection is.
Lord?
Office subjection is the counsel for appellant has not complied the following office subjection. Page number 36 to be clarified and removed, which is not a certified copy or photocopy. Accordingly, pagination and index to be rectified.
We complain.
Learned counsel for the appellant, who is physically present, submitted that he has complied all of his subjection. The court bringing to his notice that still there is single trivial and most simplest office objection to comply with. The learned counsel continue to agitate that he has complied all of his objection, and if at all any of his objection is remaining, that is for the caveat or to comply with. Next line. The court read out the office objection still due for complaints, which clearly mentions that it is for the counsel for the appellant who has to comply the office objection. And the said office objection reads as below. After hearing the same, the learned counsel prays for time. In the light of the above, imposing a cost of ₹1,000 payable by the appellant to the Legal Services Committee of this court within 3 days from today, and filing complaints memo, etc., as a final last opportunity, 1 week time is granted to comply office objection. In case if the cost is not paid and office objections are not complied within the time, registry to list this matter on on which day the court will proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection.
Number 42, Girish MS.
Report.
Number 43, HN Basuraju.
The valuation, value, 10 lakh.
Then why did you file here? No, without ascertaining the valuation slip merely because you practice in high court, you filed the appeal. Huh? No, you are not answering my question. As a counsel, were you not expected to find out the appropriate forum or the court before which the appeal is required to be filed?
After securing only this appeal has been presented before this court. Later on, what the appellant has instructed as subsequently the value has been modified and it has been placed before the trial.
You file an affidavit to that effect. You file an affidavit to that effect. The learned counsel for the appellant submits that it is only after ascertaining that the appeal lies before this High Court only he has filed an appeal. However, later the appellant got modified the valuation. As such, there was variation in the valuation. Thus, now the pecuniary jurisdiction does not lie before this High Court. Before this High Court. In order to ascertain the veracity in the said statement, the counsel for the appellant is directed to file an affidavit on the lines what he is submitted. The same is necessitated because when the court asked the learned question as to whether he has referred this appeal without confirming himself regarding the pecuniary jurisdiction of the court, the counsel had made the above submission. The needful to be done within a week from today. List the matter. No submission, please. Yes.
Cell number 44.
Item at chance 1 week, serial 21.
Till number 45, fourth time non-compliance, Samir SN. V. Manjunath.
None appear. Pass away.
Number 46, Babu M.
None appear. Pass.
Till number 47,
ಟಿಕ್ ಮಾಡುವ ಮುಂಚೆ ಫೈಲ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ವೇ ನಿಮಗೆ? ಈ ಸರ್ತಿ ನೋಡ್ತೇನೆ ನೀವು ತಿರ್ಸಿ ಕಾಲ್ ಲಿಸ್ಟ್ ಟಿಕ್ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಫೈಲ್ ಕೊಡ್ತೀರಿ, ನಾನು ಕಾಯ್ತಿರ್ಬೇಕಲ್ಲಿ.
47,
Caring for the respondent about the excavator.
Counsel for the appellant, neither present physically nor through video conference, learned counsel for pay or alone. On 26/5/2023, this court had made the following observation. In spite of the same, the appellant has neither appeared nor compared the office objection, nor even shown any reason for non-compliance of office objection. The appeal is of the year 2019. Oral and subsequent opportunities of not less than 4 times have been granted to comply with this objection, which opportunities the appellant has not utilized. Hence, the appeal stands a dismissal for non-compliance of office objection and for non-prosecution.
till number 48, J. Venkataramanappa.
Yes. The murder appeal is of the year 2020. ಇದರಲ್ಲಿ ಕೇವೇಟರ್ ಬರಲ್ಲ.
49, yes. Number 49. Yes, Narayan Swami, 914. Number 50.
Negotiating.
200 rupees per day. How many days? 1. 2 days. At the request of the learned counsel for the appellant, 2 days accommodation as spread is granted to comply with his objection, but imposing a cost of rupees 400 payable by the appellant. The Legal Services Committee of this court during the course of the day and the filing a compliance memo along with written receipt to that effect within the said time. In case if the office objections are not complied within the said time by paying cost, the matter be listed before the court on 12/6, on which day the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. Yes.
Number 51, S. Prithijaya.
Yeah, to the salad on. Search a copy on the area. Copy.
They have not complied several of the office objections as a 500 rupees per day cost. 1,000 rupees. 500 rupees per day. I can grant you any number of days up to 15 days.
This is not well, it is not done to the court. The appellant's counsel is not there. So
There are several trivial, simple office objections. When I quote the cost, I look at what are the office objection, what time is required, including non-signing of the memorandum of appeal. Memorandum of appeal not signed, he could able to secure the interim order. Interim order was granted, though there was K-wait. K-wait or remained absent. Interim order obtained. No signature in the memorandum of appeal, as such the memo of appeal itself is invalid. Not authenticated. Subsequently, got the interim order modified. No whisper about the complaints of office objection. ಆಗ್ತಿದೆ ನೋಡಿ. ಇಲ್ಲಿ ಕೂತವ್ರು ನೋಡಲ್ಲ ಸರಿಯಾಗಿ. ಏನ್ರಿ ಡನ್. 5 ನಿಮಿಷದೊಳಗೆ 300 ಮ್ಯಾಟರ್ ಕ್ಲೋಸ್. ಆಗ್ತದೆ ಇದೆಲ್ಲದು.
Sorry, my lord, I had that.
Learned.
No, no.
That's a counsel for the appellant and the learned counsel for K-wait are physically present. Perusal of the though the learned counsel for the appellant submitted the office objections are complied with and copy is served to the K-waiter. However, perusal of the order sheet will go to show that the office objections which are still open for complaints or several other office objections, including the learned counsel for the appellant not signing the memorandum of appeal. This stage, the learned counsel for the appellant prays for 2 days accommodation to comply of this objection. As such, as an ultimate opportunity, 2 days time as prayed is granted. However, by imposing a cost of ₹1,000 payable by the appellant to the legal services committee of the school during the within a day, etc. Mundindala so and so. This objection. If not done, list the matter on 19/6 on which day the court may proceed to pass. So, yes. Ask katti koodle ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿ delay ಮಾಡೋದು ಬೇಡ.
52 days was met.
ಇಟ್ಕೊಳ್ಳಿ ನನ್ನ ಪೇರು 6 times 4-5 following observation made. Reasons for coming. Dismiss non-prosecution, non-complaint.
53, Joseph Anil Kumar A. Connected.
Original or holding? Yes.
ಶಿವಕಾಲಕ್ಕೆ ವ್ಯಾಲ್ಯೂಸ್ RFA 1166 ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ ಅದು ಮತ್ತೊಂದು
ತಾವು ಯಾವ ಅಪೀಲಲ್ಲಿ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಿದ್ದೀರಿ?
RFA 1166 ಅಲ್ಲಿ ಅಪಲೆಂಟ್ಗೆ ಶ್ರೀನಿವಾಸ ಕೃಷ್ಣಮೂರ್ತಿ ನಾವು ಅಪಿಯರ್ ಶಿವಕಾಲದ ಜೊತೆಗೆ ವ್ಯಾಲ್ಯೂಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಅದನ್ನು ಕಂಪ್ಲೈ ಮಾಡಿ.
The learned counsel for the appellant in RFA 1211/2019 is neither present physically nor through video conference. The counsel for the appellant in RFA 1166 of 2019 is physically present and submits that he has complied of his objections in RFA 1166 of 2019. No reason for forthcoming either for non-appearance of learned counsel for the appellant in RFA 1211 of 2019 or for non-compliance of his objection. On 29/5/2023, by making a detailed observation and imposing a cost at the rate of ₹500 per day, imposing a cost of ₹1,000 per day. As a final last opportunity, 6 days time was granted to comply of his objection. However, the office objections are shown to be not complied yet. The office objection, a perusal of the office objection go to show that they are too simple and trivial in nature, like removal of the marking of annexures and mentioning only the number of the challenged impugned order. The complaints of the same would hardly take 2 seconds or a maximum a minute. Still, the appellant has not completed the office objection nor even appeared in the matter. Hence, RFA 1211 of 2019 stands delinked from RFA 1166 of 2019 and RFA 1211 of 2019 stands dismissed for non-compliance of office objection and also for non-prosecution. Yes.
Still 54. Manigegoda.
Bill 52. Were extracted dated 24/5/2023. The office objection not complied. This is for non.
55. Girish, next segment.
Objection. This last occasion.
This objection was already there earlier in the main appeal. Now it has been percolated to the IA.
Original objection was raised by the office. There is a description. On last occasion, your lordship has produced the certified copy of the decree available after appeal memorandum. What the office says is the typed copy of the decree, which I have furnished on 26 May 2020. I came up before your lordship on second June.
At that time, there was already an office objection regarding the not correctly mentioning the schedule in IA.
Please.
But still the court forwarded to help you by reading the impugned decree on its own. But now it has been revealed that you yourself has read the schedule in the decree otherwise. Therefore, the office objection has come up again.
Page 30 of the decree.
Yes.
Not wrong, but I have without. It's page 30 of my appeal memorandum.
Yes.
It's a certified copy of the decree.
Yes.
There's no discrepancy so far as this schedule is concerned and what I have mentioned in the now that the office raised an objection, typed a copy of the decree 86/5/2020.
Now, why you are giving it a different interpretation? You had filed the typed copy of the decree at the time of filing the memo and the certified copy, right? The description in the certified copy was not legible. Therefore, you have filed typed copy. So when you have filed a typed copy along with not clearly legible certified copy, the registry has rightly relied upon the typed copy because it is you who have filed the typed copy, showing that the typed copy is the correct typed copy of the certified copy. It has been attested also as a true copy. Therefore, your own typed copy the registry has relied upon where there is discrepancy with respect to the description of the property in the schedule. You could have read correctly the certified copy. You yourself failed to read it correctly. You yourself misread it.
Objection, there, I would have definitely requested your lordship that I would rectify this. But since I was not aware, that since this particular objection was not there.
It was there. It was there. Whosoever says that objection was not there, and if it is turned out that it was there, I am imposing heaviest cost. Sir, I am not your clerk. Subject to correction and your submission ಮಾಡದು ನಾನು ಅದರಲ್ಲಿ ಹುಡುಕಿ ಇದೆ ವಕೀಲರೇ ಇಲ್ಲ ವಕೀಲರೇ ಅಂತ ಹೇಳೋದು. The court is not your clerk. You are expected to make the correct submission only, not subject to correction. 2-8-13. However, subject to correction ಮೇಷ್ಟ್ರೆ ಅಂದ್ರೆ ನಾನು ನಿಮಗೆ ಈಗಲೂ ಓದಿ ಹೇಳಿ ಪ್ರೀವಿಯಸ್ ಡೇಟ್ ಗಿಂತ ಮುಂಚೆನೇ ಇತ್ತು ಶೆಡ್ಯೂಲ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಕರೆಕ್ಟ್ಲಿ ಇನ್ IA ಅಂತ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮುಂಚೆನೇ ಇತ್ತು. ಅದು ಆದ್ರ ಮೇಲೆ 2/6/2023 ಗೆ ಬಂದಿದೆ ಮ್ಯಾಟ್ರು. ಅವಾಗ ಇದೆಲ್ಲದೂ ಟ್ರಾನ್ಸ್ಫೈರ್ ಆಗಿದೆ. ಅದಾದ್ರ ಮೇಲೆ ಟೈಪ್ಡ್ ಕಾಪಿ ನೀವೇ ಹಾಕಿದ್ದೀರಿ ಟೈಪ್ಡ್ ಕಾಪಿ ಅನ್ನೋದನ್ನ ಆಫೀಸ್ ಮತ್ತೆ ಎತ್ತಿ ತೋರಿಸಿದೆ 2ನೇ ಸರ್ತಿ. ಅಂದ್ರೆ ಯಾವುದು ಸರಿ ಓದಬಹುದಿತ್ತು ಅದನ್ನ ನೀವಾಗಿಯೇ ತಪ್ಪು ಓದಿ ತಪ್ಪನ್ನೇ ಸರಿ ಟ್ರೂ ಕಾಪಿ ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ದೀರಿ. ಆಫೀಸ್ ಹ್ಯಾಡ್ ನೋ ಅದರ್ ಆಪ್ಷನ್ ಬಟ್ ಟು reiterate its previous objection that schedule in the IA is not correctly mentioned because you have described it as a 30.3 whereas in IA it shows as 36.3. You should have read it as 36.3 only. In the original certified, in the certified copy of the decree, of which you have filed the typed copy. ಸರಿ ಓದಕ್ಕೆ ಅವಕಾಶ ಇದ್ರು ನೀವು ಸರಿ ಓದ್ಲಿಲ್ಲ, ಅದನ್ನ ತಪ್ಪಾಗಿ ಟೈಪ್ ಮಾಡಿ ಅದನ್ನ ಟ್ರೂ ಕಾಪಿ ಅಂತ ಹೇಳಿ ಹಾಕಿದ್ದೀರಿ ನೀವು. ಆಫೀಸ್ ಅದನ್ನು ನೋಡಿದೆ. ಯಾಕೆಂದ್ರೆ when the original certified copy is not legible, it has to rely upon the typed copy because you have filed the typed copy as a true copy.
It is sufficient with this. It is mentioned the typed copy of the decree, but it is wrongly mentioned. Not my humble submission. In case not because the object in the last occasion, maybe I would have requested your lordship that I will rectify it in lordship at India. This is the last occasion where not the office objection was only confined to schedule, not about the typed copy. But I-
Not necessary. Not necessary. Why should it? Why should it? ನಿಮಗೆ ಬೇಕಾಗಿರೋದು ಎಲ್ಲದನ್ನು ಸಾಂಬಾರು ಬಿಡಿ ಸರಿ ಅಂದ್ರೆ ಸಾಂಬಾರು ಮಾಡುವ ವಿಧಾನನ ಅವ್ರು ಹೇಳ್ಬೇಕಂತ ಇಲ್ಲ. ಗುಣಮಟ್ಟಕ್ಕೆ ಅನುಗುಣವಾಗಿ ಸಾಂಬಾರು ಮಾಡಿಲ್ಲ ಹೇಳ್ತಾರೆ. ನೀವು ಸಾಂಬಾರನ್ನು ಹೀಗೆ ಮಾಡಬೇಕಿತ್ತು, ಅದಕ್ಕೆ ನೀರನ್ನು ಇಷ್ಟು ಕುದಿಸಬೇಕಿತ್ತು, ಇಷ್ಟು ಉಪ್ಪು ಹಾಕಬೇಕಿತ್ತು, ಹುಣಸೆ ಹಣ್ಣು ಹೀಗೆ ಹಿಂಡಬೇಕಿತ್ತು, ಈ ಊರಿನ ಹುಣಸೆ ಹಣ್ಣನ್ನೇ ತರಬೇಕಿತ್ತು. ನನ್ ಆಫ್ ದ ಬಿಸಿನೆಸ್ ಆಫ್ ದ ರಿಜಿಸ್ಟ್ರಿ. Schedule ಸರಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ it was expected of you to keep what schedule you have mentioned or shown or placed before the court in the memorandum of appeal. You only have filed the typed copy showing it as 30.3. In IA you have mentioned it as 36.3. That is the only discrepancy in the schedule. Why should the office tell you all those things written in a paragraph? In the typed copy, there is a discrepancy as 30.3, whereas the IA mentions it as 36.3. Sir, you yourself has filed the typed copy stating that this is legible, this is true copy, this is correct. As such, they compared it with the typed copy of the decree, which was a variance in the IA schedule. Rightly mentioned, IA schedule doesn't tally with the main. ಈಗ ನೀವು ಏನು ಹೇಳಲಿಕ್ಕೆ ಹೊರಟಿದ್ದೀರಿ ಅದು ಬಹುಶಃ ಚತುರತೆಯ ಹೊರತು ಪ್ರಾಮಾಣಿಕತೆ ಅಲ್ಲ. ಪ್ರಾಮಾಣಿಕತೆ ಏನಿರ್ತಿತ್ತು, ಸ್ವಾಮಿ ನನ್ನಿಂದ ತಪ್ಪಾಗಿದೆ, ಡಿಗ್ರಿಯಲ್ಲಿ 36.3 ಅಂತ ನಾನು ಓದಿದ್ದೇನೆ, ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿದ್ದೇನೆ ಅಂತ ಆದ್ರೆ ನಾನು ಅದನ್ನು ಟೈಪಡ್ ಕಾಪಿಯಲ್ಲಿ 36.3 ಅಂತಲೇ ಹಾಕ್ಬೇಕಿತ್ತು. ನಾನು 30.3 ಅಂತ ಹಾಕಿದ್ದೇನೆ, IA ನಲ್ಲಿ 36.3 ಅಂತ ನಾನು ಹಾಕಿದ್ದೇನೆ. ಏನೋ ಕಣ್ತಪ್ಪಿನಿಂದ ಆಗಿದೆ ಸ್ವಾಮಿ, ಒಂದು ಅವಕಾಶ ಕೊಡಿ. ಅದು ಒಂದು ಪ್ರಶ್ನೆ. ಹೋದ ಬಾರಿಯೂ ಹೇಳಿ, ಈ ಬಾರಿಯೂ ಹೇಳಿ, ಈ ಬಾರಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಸರಿ ರೈಸ್ ಮಾಡಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಿಮ್ಮದು ಪ್ರತ್ಯಕ್ಷ ನೇರ ಲೋಪ ಏನಾಗಿದೆ ಅದರ ಬಗ್ಗೆ ಕಿಂಚಿತ್ತೂ ಗಮನ ವಹಿಸದೆಯೇ ಲೋಪವಿಲ್ಲದ ಕಡೆ ಬೆರಳು ಮಾಡಿ ತೋರಿಸುವ ವ್ಯರ್ಥ ಪ್ರಯತ್ನವನ್ನು ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಆನ್ ಕಾಸ್ಟ್ ಇಷ್ಟೊತ್ತು ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿದೆ. The learned counsel for the appellant, who is physically present, initially attempted to show that the registry has not raised the objection with respect to the alleged discrepancy in the schedule in the interlocutor application at the earliest point of time. However, when the court brought to his notice that at the earliest point of time, the registry has raised the objection stating united comma, schedule to be stated correctly in IA. It cannot be said that the registry has not raised such an objection. Till the learned counsel for the appellant submitted that the registry ought to have brought to his notice that in the typed copy, the scheduled property is shown as 30.3, whereas in IA it is shown as 36.3. Next line, I consider the said submission is bereft of any bona fideness in it, since the very typed copy of the judgment and decree has been furnished and filed by none else than the appellant himself, certifying the same as a true copy. As such, rightly the registry has relied upon the typed copy of the judgment and decree, since the certified copy were not legible. As such, when there is a discrepancy with respect to the description of the property with the true copy, with the typed copy filed by the appellant to that of the interlocutory application, the registry has rightly raised the said objection at the earliest point of time. At this juncture, the learned counsel for the appellant prays for time to rectify the same and to comply the office objection. Since, including on the previous date of hearing, the appellant has taken sufficient and precious time of this court for no valid purposes, imposing a cost of rupees 1,000 payable by the appellant to the Legal Services Committee of this court within 2 days from today, and filing a complaint memo, etc., etc. As an ultimate opportunity, 1 week time is granted to do needful. In case if the cost is not paid and complaints is not done within the time list, this matter on 21/6, on which day the court may proceed to pass so and so, so and so. Yes.
Serial number 56, Ashok Kumar BG.
ಒಂದು ದಿವಸಕ್ಕೆ 200 ರೂಪಾಯಿ. ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ, ಕೊಡಬಲ್ಲೆ. ಮ್ಯಾಕ್ಸಿಮಮ್ 10 days. ಮೈಕ್ರೋಫೋನ್ ಯೂಸ್ ಮಾಡಿ. 2-3 days ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು 2.5 ದಿವಸ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. 2 ದಿವಸ ಕೊಡಬಲ್ಲೆ, 3 ದಿವಸ ಕೊಡಬಲ್ಲೆ. ನಿಮ್ಗೆ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಕೇಳಿ. 2 days. Learned counsel for the appellant once again prays for time in this appeal. Considering the observation made on 24/5/2023 when the court suggested to the learned counsel that in granting of any further time would be only on a cost at the rate of ₹200 per day payable by the appellant. The learned counsel for the appellant opts for 2 days accommodation, hence imposing a cost of ₹400 payable by the appellant to the Legal Services Committee of this court during the course of the day, and filing a complaint memo, etc., etc., etc. As an ultimate opportunity, 2 days as paid for is granted to comply of his objection. In case if not complied, etc., etc., in total, list this matter on 20. Yes.
Serial number 57, NV Manjunath, orders matters.
And for the respondent number 1.
1 minute. So what is the submission of respondent in the matter?
My lord, with respect to the memo filed by them, I have no objection. They have filed a memo for the withdrawal. I have no objection, my lord.
Whether the copy of IEA is served to you?
I'm not the counsel on record. Yeah,
Registry has raised an objection. Comply the objection. ಅದನ್ನ ಫಸ್ಟೇ ಹೇಳ್ಬೇಕಿತ್ತಲ್ವೇ? ಅದನ್ನ ಬಿಟ್ಟು ಉಳಿದಿದ್ದು ಎಲ್ಲದೂ ಹೇಳಿದ್ರಿ. Also for the appellant physically present and praise for a week's accommodation to comply with subjection raised on a 1/23. Both for the caveat or is appearing through video conference. Time spread is granted.
Number 58, Gangadhar Aikar.
Period. 22-6.
59, KK Vasan.
Take steps to respond on the second time that is there left there.
Counsel for the appellant prays for 10 days accommodation to take
And it
First
was
step.
granted.
respondent number 3 and 4. The time has spread is
Tomorrow
granted.
dated 17/4.
Interim order granted on 17/4/2023 is extended by 2 weeks. Yeah.
Number 60, Krishnamurthy N.
Not mentioning of the details of respondent. I use this name, I guess respondent number 3 now.
1 minute. Yes, what are your submissions?
During office objection based on serial number 1 to 3. In the course of the day. Regarding office submission from serial number 4. Non mentioning of the details of respondent number 3 in the IA. Interim application, no relief is claimed against respondent number 3 in the IA. More than that, he has remained expired in the trial court and he is not.
All the things you should have said submitted in the registry. They would not have raised the office objection.
The orders dated 12/4/2023 has been complied by the depositing amount of which is 1 lakh by the on 2/6/2023. Memorandum of appeal also I mentioned that respondent number 3 notice to be dismissed as he is not contested in the trial and also has remained ex parte in the suit.
Yes, what is your submission then? You would comply office objections. Fine. During the course of the day. When you want the matter to be listed again? Next week any day.
Yes.
Yes. Learned counsel for the appellant submits the
Notice is also has to be served on the respondent.
to comply the office objection during the course of the day. And press to list the matter in the next week. He also submits that he would take first steps to respondent number 1 and 2. List the matter in the next week.
In order.
Not extended.
Hearing on interlocutory application, seal number 61, MS
It is for
Varadarajan.
that reason only I asked you in detail. Yes,
This for recovery, my lord.
yes.
I have no liability to make the payment. I have not taken.
No,
back
the-
Sincere apologies. my
Since
lord.
the very purpose of issuing emergent notice was for ensuring the service of notice upon the respondents, including respondent number 3. And the appellant has not even paid the process till today, even for the first time as against respondent number 3, though he has been arraigned as a respondent. And-
Because he has removed expertly before the trial court. And he has not-
Dispensation ಆಗ್ಲಿಲ್ಲ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಇರೋದು ಈಗ ಆಸ್ ಅಗೇನೆಸ್ಟ್ ಎಲ್ಲರೂ ಅಗೇನೆಸ್ಟ್ ಇದೆ.
Respondent number three, I made a submission to the court also, my lord. It's not-
ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ ಇಲ್ಲ.
Process has been paid. Once the answer
Hence
was
the
given,
interim order is not extended.
process has
However,
been
he is at
paid.
liberty to comply of his objection in all respects
Sincere apologies.
and to pray for interim order in a process in a manner known to law. Yes.
Hearing on interlocutory application, seal number 61, MS Varadarajan.
About first intent, if it does something and this was like property constructions. Let us start on 7. ಯಾವುದು ಇದೆ? Not 22. Point of objections.
ಮುಂದೆ ಹೇಳಾಗಿತ್ತು ಮ್ಯಾಟ್ರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ಟೇಟ್ ಹೆಸರು ಬಂದು
ಇದರದ್ದು ಇವರದ್ದು ಒಂದು ಬಂದಿತ್ತು ಅದರಲ್ಲಿ ಇದೇ ಚಿತ್ರ ಇತ್ತು ಇದೇ ಫೋಟೋ ಇತ್ತು ಇದು ನಮ್ದು ಬಂದು ಹಾ ಹೇಳಲ್ಲ ಹ್ಞೂ ಹೇಳಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ. Yes. Yes, in the connected matter,
Yes.
a submission was made that only compound wall was put confined to property except compound wall, no development has taken place. My court officer is misleading me. ಈಗ ಇದರಲ್ಲಿ ಐಎ ಸರ್ವೈವ್ ಆಗಲ್ಲ ಅಲ್ವೇ ನಿಮ್ಮ ಪ್ರಕಾರ?
Separate individual sites.
Whom you appear for?
Appellant.
Appellant. After you filing IA, the interim order was modified, right?
Modified.
Interim order was modified. By virtue of modification of the interim order, he was at liberty to carry out the development work in the remaining portion of the
Remaining
property, excluding the suitable property, right?
Yes.
So is it your case that it is suitable property also, as on date, he is continuing to carry out any development activity? No. Then how come your IA 1/22 survives for consideration?
That contact only your lordship has disposed of.
ತಡೀರಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರ ಸೀನಿಯರ್ ಬಂದಿದ್ರು, ಅವ್ರು ಬಂದು ಹೋದ್ರು, ಈ ಸರ್ತಿ ಇವ್ರನ್ನ ಕಳಿಸಿದಾರ, ಹೋಗಪ್ಪ ಅದ್ ನೀನೇ ಹೋಗಿ ಮಾಡು. ಮತ್ತೆ ಇದನ್ನ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? You are withdrawing IA 1/22. Learned counsel from both sides present. Learned counsel for the appellant submits that he would not press IA 1/22, for which the learned counsel for K. Vetter has no objection. In the light of the above, IA 1/22 stands dismissed as not pressed. As an ultimate opportunity, 2 weeks' time is granted to file paperwork.
Silver 62, Narayan Swamy PM. Serial number 62.
Declaration and extension. Appellant filed a suit for file for notice. This is 41 of the GM. Building advocate, appellant number 2, advocate architect, public of record 19.
You have any objection to IA 1?
So for the number 1 is concerned.
Learned counsel from both
Number 2
sides.
is concerned. I will file.
Counsel for the respondent submits his no objection to allow IA 1/19. Foreign activity delay condonation of 41 days. 1/19 allowed a delay of 41 days in filing the appeal. Stands condoned. Next line, as prayed for by learned counsel for respondent. 10 days time is granted to file their objection if any to IA 2/19.
Serial number 63, Rakshit KN.
Then call for TCR.
Cell number 63.
Counsel for appellant. To heard the submission of current counsel for the appellant, there is the memorandum of opinion. Between the issue notice to the respondents both on the main appeal and on IA. Heading IA. Appellant to pay the necessary process and furnish copies in the registry if not already done within a week from today. The meantime, call for TCR. Yes.
64. Balgangadhar GS.
Incident 64 either for respondent KM.
Well, paper books a lot there. My apologies to the honorable court. 3 weeks I. Paper books.
Counsel from both sides present. As requested for by 11th counsel for the appellant. 4 weeks time is granted.
Cell number 65. Murthy K.
Much obliged.
This matter for consideration of file number 1 of 2023, my lord. The meantime, the notices to respondents for 1 to 4, my lord. As per the postal track, it is notice is served on number 23. Even for 1 and 4 also served, my lord. They are unrepresented.
Note ಎಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ? Is the matter on 7-6? Where is the note? ಹಳೆದಲ್ವೇ? ಅದಕ್ಕೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆದ್ರ ಮೇಲೆ ಮತ್ತೆ ನೋಟ್ ರಿಪೀಟ್ ಆಗ್ಬೇಕಲ್ವೇ ಅದು? ಪ್ರೋಗ್ರೆಸ್ ಇದ್ರೆ ಏನಾದ್ರು ಬರಿಬೇಕಲ್ವೇ? ಬರ್ದಿಲ್ಲ. The Learned Counsel for the appellant is physically present. A perusal of the order sheet will go to show that after the hearing date 1/6/2023, the registry has not recorded the proceedings in the order sheet. Hence, the matter is passed over. The registry to do needful. Call the matter at 2:30 p.m.
Cell number 66. Vijay AM. Connected. Cell number 66. RFA 1825/2021.
Madam. 6.1 manner. Before the respondent to submit, we are about to submit the render the other code. So, I think
Request of the Traffic Council for respondent number 17 and 18 in RFA 1176/2021. The matter is passed over. Yes.
Serial number 67. Rajesh Rapian.
Notice order ಮಾಡಿದ್ದೀನಿ previous minute. ಸಮಯನಂದ ನಗಿ. Here. Yes.
Serial number 68. Renuka.
Is there any standing counsel or panel advocate for BDA?
Yes, my lord. I have served the copy on the panel advocate.
Can you request the said counsel
Mr.
to
Anand.
be present here?
He is not present.
Can you request the said counsel to be present here so that I can direct him to take notice?
But
You save time. Yes. Bring him. Yes. Matter is passed over at the request of the learned counsel for the opponent. Yes.
Serial number 69. Muniraju.
Notice is here.
Serial number 70.
Notice is here. Pay process. Yes.
71. Amresh Andy.
Notice is here.
Serial number 72. Varaprasad.
What was the mandatory injunction you had sought for?
My lord, suit for injunction initially filed, my lord,
Hmm.
where in the possession of the site, my lord.
Hmm.
And it has been disposed from the site and they have started to construct the building, my lord. Therefore, we amended the claim and we sought for mandatory injunction.
Notice.
Admission matter,
Main and I.
admission matter, civil 73, Amit A. Mandagi.
Restrictive right of light and air, my lord. Also, honestly, there is such a being without criteria. Buildings, my lord.
Yeah, one moment. Yes. Whether the assistant executive engineer executed the direction,
Take fresh instructions.
whom you appear for, responding,
DDMP. Responding.
you have not filed your file.
my wakalat minutes on February 7 February 2022. I have filed my wakalat minutes. I need to take instruction minutes. I don't have set up papers also. I pay for 2 weeks accommodation minutes. In the meanwhile,
Can you name the advocate who has filed wakalat for BBMP?
color achievement.
Then it shows Amit Deshpande for R2 wakalat not filed.
Voted directly.
Directly.
What had happened? There was past 21, we were asked to serve on the standing council. Third, these papers, my lord, on the standing council, Mr. Amit Deshpande, my lord, on 24/1/2022. Memo was also filed, my lord, so that 24/1/2022. That's why the name of Mr. Amit Deshpande was being shown.
Thereafter, in the month of February, matter has been entered into my minutes.
Learned counsels from both sides present. Learned counsels from both sides submit that since Mr. Sumangala Gichenmat continues to appear for respondent number 2, the name of Shri Amit Deshpande need not be shown in the cause list as the counsel for respondent number 2. Registry to take note of the same. Yes. We haven't executed the direction. Yes,
Just to take instructions minutes whether the
1,000 rupees per day. How many days you want?
filing my wakalat is the first time it is.
ನಾನು ಕಾಸ್ಟ್ ವಕೀಲರು ಕೊಡ್ರಿ ಅಂತಿಲ್ಲ, ನಾವು BBMP ಹತ್ರ ಇಸ್ಕೊಳ್ಳಿ. ನಿಮಗೆ BBMP ಬರ್ಬೇಕಾಗಿರೋ ದುಡ್ಡೆಲ್ಲ 5 ರೂಪಾಯಿ ಬಿಡ್ತೀರಿ ನೀವು? ಇಲ್ಲ ತಾನೆ? ಅದರಲ್ಲಿ ಲೆಕ್ಕಾಚಾರ ಕರೆಕ್ಟ್ ಇರ್ತದೆ. ಆಫ್ಕೋರ್ಸ್ ಬೇಕಾದ್ರೆ 5 ಕೋಟಿನೂ ಬೇರೆ ರೀತಿ ವೇವ್ ಮಾಡ್ತೀರಿ, ಅದನ್ನ ಬಿಡಿ.
Accommodation minutes, I just filed my
ಕೊಡ್ತೇನೆ
report.
1,000 ರೂಪಾಯಿ ಪರ್ ಡೇ. ನಿಮ್ಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ನಿಯರ್ಲಿ 1.5 year ಆಗಿದೆ. ಯಾವ ಗನಂದಾರಿ ಕೆಲಸ ಮಾಡ್ತೀರಿ? ಅಷ್ಟು ದೊಡ್ಡ ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್, ಅಷ್ಟು ದೊಡ್ಡ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಬಾಡಿ, ಬೇರೆದ್ರಲ್ಲೆಲ್ಲ ದೊಡ್ಡ ದೊಡ್ಡ ಮಾತಾಡ್ತೀರಿ. ನಿಮ್ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಜವಾಬ್ದಾರಿ 1.5 ವರ್ಷ ಆದ್ರೂ ಮಾಡಲ್ಲ. ಟೈಮ್ ನಿಮ್ಮ ಒಂದೊಂದು ದಿವಸದ ಡಿಲೇನು ಕೂಡ ಇದರಲ್ಲಿ ಪ್ಲೈಂಟಿಫ್ಗೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಮಾಡ್ತದೆ ಅನ್ನೋದು ಅರಿವಿದೆಯೇ ನಿಮಗೆ? ಅವ್ರ ಕಂಟೆನ್ಷನ್ ತಮ್ಗೆ ಲೈಟ್ ಇಲ್ಲ, ಏರ್ ಇಲ್ಲ. ಇಫ್ he is deprived of air and light for years together, what's the guarantee that he would survive? What about his health condition? So 1,000 rupees is only a nominal cost. Tell me how many days you want, I grant you time.
Minutes. I will take instructions, file my report. Conducted the
36 days.
Friday minutes, I will take instructions.
3 days.
Their apology minutes.
Absolutely not. ನೀವು ಸರ್ಕಾರಿ ಇಲಾಖೆಯವರು ಅಧಿಕಾರಿಗಳು ಅಪಾಲಜಿ ಎಕ್ಸ್ಕ್ಯೂಸು ಅನ್ನೋದ್ರಲ್ಲಿ ನಿಸ್ಸೀಮರಿದ್ದೀರಿ. ಮಾಡೋದೆಲ್ಲ ಮಾಡಿ ಆಮೇಲೆ ಬಂದು ಸಾರಿ ಅಪಾಲಜಿ ಬಿಟ್ರೆ ಮುಗಿದೋಯ್ತು, ಎಲ್ಲದು ಮುಗೀತದೆ ಅಂತ. If an individual commits a mistake, we can ignore excuse. If a body like you, a statutory body or a corporation does it, we have to be more stubborn and serious. ಹೇಳಿ, you are wasting the time of the court. ಎಷ್ಟು ದಿವಸ ಬೇಕು ಕೇಳಿ?
3 days.
3 days. Learned counsel from both sides. Learned ಬಂದಿದೆ. The learned counsel for respondent number 2 prays for 3 more days time to. ನಿಮಗೆ 3 ದಿವಸದೊಳಗೆ ಆಗಲ್ಲ, ಅವಾಗ ಬಂದ್ರೆ ನಿಮಗೆ ಮತ್ತೆ ಮೋರ್ ಸೀರಿಯಸ್ ಅಬ್ಸರ್ವೇಷನ್ ಆಗ್ತದೆ. ಈಗ 3 days ಅಂತ ತಗೊಂಡ್ರೆ 4th day ನಾನೇ ಇರ್ತೇನೆ. ಯಮಧರ್ಮ ಹೇಳಿದಾನೆ, ಇರ್ತೀರಿ ನೀವು ಒಂದು ವಾರದವರೆಗೆ, ಯೋಚನೆ ಇಲ್ಲ ಅಂತ.
Time, my lords, because I don't know whether they have conducted this.
ಅದೇ ಏನು ಗೊತ್ತಿಲ್ಲದೆ ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಅನ್ನೋದು ಕೋರ್ಟಿಗೆ ಗೊತ್ತಿದೆ. ಏನು ಗೊತ್ತಿಲ್ಲದೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಕೇಸ್ ಬಂದ್ರ ಮೇಲೂ ಕೂಡ ಕನ್ಸರ್ನ್ ಸೆಕ್ಷನ್ ಅವ್ರನ್ನ ಏನಾಗಿದೆಪ್ಪ ಡೆವಲಪ್ಮೆಂಟ್ ಅಂತಲೂ ನೀವು ಕೇಳಲಿಲ್ಲ. ಪ್ರೇ ಫಾರ್ ಟೈಮ್ ಎಲ್ಲರೂ ಕೊಡ್ತಾರೆ, ಇವರು ಕೊಡ್ತಾರೆ ಅಂತ ಬಂದ್ರಿ ಅಂತಲೇ ನೀವು ಬಂದಿದ್ದೀರಿ. ದಟ್ ಈಸ್ ಕ್ವೈಟ್ ಕ್ಲಿಯರ್ ಅಂಡ್ ಶೋ. Initially paid for a week's time to make submission and to file report as per the direction dated 14/1/2022. After the court brought to our notice that the said direction due for execution by respondent number 2 was passed nearly 1.5 years back, that is on 14/1/2022, the learned as such granting of any time would be imposing a cost at the rate of rupees 1,000 per day payable by the respondent number 2, comma, the learned counsel. Reduce the requirement of the time for 3 days. Hence imposing a cost of rupees 3,000 payable by the respondent number 2 to the Legal Services Committee of this court within a day from today and filing a complaints memo along with original receipt to that effect within the said time as a final last opportunity. 3 days time as credit is granted. It is also made clear that non-compliance of the direction dated 14/1/2022 within 3 days from today would attract the further observations by this court, including the observation regarding the non-compliance of the direction of the court. List the matter. 14/6.
Yes, I pray for a copy of this order.
If you can obtain, you obtain it. If you are entitled for free copy, obtain there. If you have to pay, pay it and get it.
Number 74, Vidya S.
You have heard the order, communicate it.
Still number 74.
Yes, please.
Join the principal independent institution and on a contact basis. He joined in the 10 to 6 2022 and for the period of
At the submission of land counsel for the appellant, there is a memorandum of appeal and I issue emergent notice to the respondent both on the main appeal and on IA. Appellant to pay the necessary process and furnish copies in the registry if not already done within a day from today. Registry to list the matter immediately after service of notice upon the respondent. Yes.
Number 75, Manjunath.
ಸಂತೋಷ. 1 ವರ್ಷ 2 ತಿಂಗಳು ನೀವು ನಿದ್ದೆ ಮಾಡಿದ್ದೀರಿ. ಯಾರು ಡಿಲಿಜೆಂಟ್ ಆಗಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಬರ್ತಾರೆ, ಏನೂ ತೊಂದರೆ ಇಲ್ಲದೆ ಸ್ಟೇ ಕೊಡ್ತೇವೆ. ಯಾರು ತಾವಾಗಿಯೇ ನಿದ್ದೆ ಮಾಡ್ತಾರೆ ಎದುರುಗಡೆಗೆ ನೋಟಿಸ್ ಹೋಗಿ ಬರಲಿ. ನೀವು 1 ವರ್ಷ 2 ತಿಂಗಳು ಸುಮ್ಮನೆ ಇದ್ದೀರಿ. ಬೀಯಿಂಗ್ ಎನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್.
Number 75, Manjunath HA.
Specific performance. And for this appeal and this judgment and the possible. Yes. The share. Documents and evidence. But one and PW two is a husband of PW one. Husband of client A. Clearly admits that the legal notice issued by them mentioning wrong address. Unwillingness not proved. They have not proved the financial capacity of the client. If the court come to the conclusion that they have not produced any document to show that they have financial capacity, come to the conclusion that implied they have aware that they are asking financial capacity.
Emergent notice, same order. Process cut. Yes.
Bill number 76, Mr. Prakash.
Girish. Cancellation of the lease is scheduled, executed by the dependent number one in the power of dependent number two. In the guise of Ali's disputed section 4 of the document.
Who appears for K beta?
Siddesh. Okay, what else from two?
The notice has been ordered. No. Also for the appellant present. For distribution, there is the memorandum of appeal in the judgment. Issue emergent notice to the respondents, both on the main appeal and on the 2/22. Respondent number. K beta is R2, right? Yes. Respondent number 2 is being is K beta. Appellant to pay the process and furnish copies in the registry, if not already done. The registry within a day from today. List the matter immediately after service of notice. Yes.
Number 77, Prakash MS.
Counsel for the appellant submits that arising out of the very same common judgment. One more appeal bearing number so and so is pending and prays to list both the matters together, register to verify and do needful. Yes, Lord.
Number 78, P. Venkatraman.
I appear for the respondent Kevtar.
For possession and for damage filed with the plaintiff. Typically, Roganathan was one of the property. And then after his death, he had 4 sons and 2 daughters. And the 4 sons have partitioned the suit property by leaving the 2 daughters. And the appellant is, this is the defendant, was one of the daughters. We have to find a suit for possession and damages against Jyotika, that is one of the daughters of Roganathan. Their case is that she is in permissive position and she is allowed to be evicted and she has to pay damages.
For the submission of learned counsel for the appellant who is physically present. The appeal and I1 got into produce the memorandum of appeal and again the impugn judgment. Issue emergent notice to the respondents. Learned counsel Sri Bonendra Raju P, who is also present, submits that subsequent to filing of appeal, he has filed a caveat for respondent number 1. As such, he accepts notice for respondent number 1. He is permitted to accept notice for respondent number 1.
I will file the wakalat for all the other respondents.
Submits that since I already filed wakalat, he continues to appear for respondent number 1. The said submission is taken on record. The appellant to pay the process and furnish copies in the registry, if not already done, for issuance of notice to the remaining respondents.
My humble submission, my lords, the appellants were in permissive position of the premises. Some reasonable time can be granted to them for vacating, my lords. They have been enjoying the property without even paying a single pie for almost 15 to 20 years.
ಯಾರ ಜೂನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಅರ್ಧ ಗಂಟೆ ಲೆಕ್ಚರ್ ಕೊಡ್ತಿದೆ. ನೀವು ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ನಲ್ಲಿ ಇದ್ದೀರಿ, ದೂರ ಇದ್ದೀರಿ. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕ್ರಿ. ಮೇನ್ ಟೈಮ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 to file their objection if any on IA1 got 22.
79, Ananthanarayan.
For partition. You are dismissed solely on the ground of limitation and have not proved that the item suit properties are the not joint family properties. DW1 admits in the class examination, the plaintiff is entitled share in item number 1 of the suit property. Admittedly, item number of property was purchased by my grandfather. After death of my grandfather, my father succeeded. Myself and defendants want to file the only legal case. So entitled share is item number 1 of the property.
Kevator Upilum Kuchri.
Shivkumar V. Okay, what are respondent 8 and 9?
Counsel for the appellant physically present for this submission. There is the memorandum of appeal, and 1/22 judgment. To emergent notice to the respondents, both on the main appeal and on IA. Respondent number 8 and 9 are Kevators and Learned Counsel submits that he continues to appear for respondent number 8 and 9. The appellant to pay the necessary process and furnish copies in the registry for service of notice to other respondents. Not already be done within a day from today. List the matter immediately after service of notice to respondent. In the meantime, to file their objection if any to IA 1/22. Yes.
Serial number 80, Syed Akmal Hassan Razvi.
My humble request for granting a week or 2 time. Senior is out of town. Senior is out of town, so requesting for 1 week or 2.
TCR. Yes.
Serial number 81, RB Sadashiv.
To dismiss on preliminary issue.
The period.
Lease is still in existence.
No. That is why it was dismissed.
No, lease is still in existence. You said no.
No. Lease was for 35 years. Lease came to an end. They filed a suit for renewal of the lease for another 5 years. During the pendency of that 5 years, during the pendency of the suit, that additional period of 5 years also came to an end. And they were enjoying the property for that 5 years. Court said, I cannot decree a suit for you to enjoy property in the past. Therefore, the suit came to be dismissed. They filed one more suit, my lords, in respect of another period of 5 years. That suit is also dismissed.
No, Lease was in whose favor? His favor or?
Lease was in favor of the present appellant. It was for a period of 35 years. Lease started on 1981.
Had you taken a concession in the trial court that the suit has become infructuous
Yes,
as lease was extended for further period?
but we had taken up only two contentions. The first contention was that he is not entitled to an automatic renewal of the lease. You have to prove all requirements. And second contention, by the time we received the summons in the suit and entered appearance, the period for which the decree was sought for had already expired. The court felt there is no purpose in decreeing the suit for a period which is already expired, and he was in enjoyment. I had independently filed a suit for ejectment. A decree was passed in my suit for ejectment. That is confirmed by this court by a division bench of this court in an RFA. There is no purpose, my lords, in the present. But may I request this court to kindly take internal page 13 of the judgment.
Yes.
I'll read from page 12 minutes.
Yes.
The clause relating to renewal is there. The lessor and the lessee hereby covenant that the duration of the lease shall be 30 years certain, commencing from the 15th day of February 1981, on which date the lessee is put in possession of the leased area. Renewable at the option of the lessee for further periods of 5 years each, subject to increase rent specified in clause 3 by executing the circuit deed. This was the clause which was put in force. My lords, at page 13, my lords, second paragraph. During the pendency of the suit, further period of 5 years from 16th of February 2016 to the 15th of February 2021 is expired. As for the terms and condition number 4 of the said deed of lease, plaintiff may exercise its option for renewal of the lease for a further period from 16 to 2021 to 15 to 2026 on the same facts pleaded in the suit. Now, for that period, he has filed a suit, and that suit is also dismissed. For the further period from 16th February 2021 till the 15th of February 2026, he has filed a suit. That suit is also dismissed. Now, my lords, the prayer in the suit is extracted, my lords, in the judgment itself. I have, my lords, at the instructions of this court, filed around 4 documents, my lords, along with a memo on the 12th of April 2023.
So the suit was for specific performance for a specific direction to renew the lease.
Yes.
From February 2016 to February 2021.
Yes.
And the said period is already over now.
Over.
And from 2021, did you opt for, you are the lessee?
Yes, yes.
You are the lessor.
I am the lessor.
So did you opt for subsequent renewal from 2021 to 2026?
He filed a suit for reject.
When, in which year?
Subsequently, appeals is now by the Supreme Court. There is an order of status quo with regard to possession and other things. Obviously, we have filed the appeal because unless we seek extension of this period of lease, I cannot subsequently ask for. Though the clause says that every 5 years, yes.
One second, I come to that. From 2000, this suit was for the extension from 2016 to 2021, right?
16th February 2016 till the 15th of February 2020.
from 16th February 2021 up to 15th February 2026. Have you made any request for further renewal of the lease in any manner to him?
Is 5496 of 2021.
That is for what relief?
For specific, I have produced that.
No. For specific performance,
For renewal of the lease for another 5 years from 2021.
21 to 26.
Yes.
That is still pending
No,
now.
my lords, that suit is dismissed.
That suit is dismissed.
Yes.
Yes. Dismissed?
For default, my lord.
Dismissed for default. Fine. You said Supreme Court status quo. Who went to the Supreme Court upon which order? You went to the Supreme Court. Obviously, it required of you. Yes. Against which order or for what you approached the Supreme Court?
Degree of
It
ejectment.
seems wrong, very seems wrong. That clause says for 5 years it should be renewed. Therefore, when I fought for renewal of that 5 years subsequently, he could not have received what the eviction order against.
You went to the Supreme Court against the order passed in that particular version of suit which was dismissed for default.
No.
No.
I have gone to Supreme Court against the order of the division bench of this honorable court, which has confirmed the order of ejectment passed to the court.
I filed a suit for ejectment.
Apart from these two suits,
My lords,
filed by
first-
him.
First was my suit for
ಅದು
ejectment.
ಒಂದೊಂದೇ ಹೊರೆ ಬರ್ತಾ ಇದೆ. ಒಂದು ಕೇಸ್ ಇತ್ತು, ಒಂದು ಹೋಗಿ ಎರಡಾಯ್ತು,
ನಾನೇ ಹೇಳಿದೆ.
ಎರಡು ಹೋಗಿ ಈಗ ಮೂರಾಯ್ತು.
ನಾನೇ ಹೇಳ್ತೀನಿ.
ಹಾ.
ನಾನೇ ಹೇಳ್ತೀನಿ. In 2010, in the first instance, I filed a suit for ejectment.
ಹಾ.
That suit came to be dismissed during the holding that the suit is premature. The
Which
lease
year you had filed?
I had filed in 2010. OS
10.
361 of 2010, I
Ah.
filed.
Premature.
The suit came to be dismissed that it is a registered lease deed
Ah.
giving in 30 years. and
Wait for
therefore
30
I did
years.
not- During the pendency of OS 361 of 2010, the statutory period of 30 years had come to an end.
Hmm.
But I still prosecuted the suit, my lords, and that suit came to be dismissed.
Hmm.
I accepted the judgment and decree. I did not take it up further.
Hmm.
I issued a fresh notice. Lease was for industrial purpose.
Hmm.
Issued a notice under section 106 stating it to be a tenant from month to month. I could have, my lords, on the last day instituted a suit, but the previous suit was pending. I treated him as a tenant from month to month, from year to year because of industrial lease. Gave him 6 months to vacate the premises. He did not. Then I filed a suit for ejectment, my lords, in 2017. It had to be represented, my lords, from the rural court to the civil court here at Bangalore because of some issue related to jurisdiction. Suit was represented. Defendant entered appearance, that is, my lords, the present appellant, entered appearance and took up only one content. I have filed a suit for specific performance, and therefore this present suit will have to be kept in abeyance. Now, my lords, the trial court, and he requested for both the suits to be clubbed. Lords, this court, following previous judgment, said that a tenant suit for specific performance cannot keep a landlord suit for ejectment. His right is independent, and if he succeeds, he will have to take possession then. But however, transferred both the cases to the same court, directed the court to decide both the suits, if not jointly, at least simultaneously. And lords, his suit for specific performance came to dismiss on the sole ground that it is infructuous. The period is already come to an end, and the decree cannot be given for a period in the past.
Which was that suit?
My lords, that is, my lords, OS 8511 of 2018.
Ah.
Lords, after that suit was decreed, both of us challenged it before the division bench of this court on different grounds. He challenged the ejectment. I challenged insofar as, my lords, the taxes in respect to the property. It was a very long lease of vacant land. He was required to pay the taxes for the property. Lords, he does not pay the taxes, then I have saddled with the liability. My suit for recovery of taxes paid to BPMP came to be rejected with a ground of limitation for certain years. To that extent, I was before the division bench in appeal. My learned friend was in appeal on the issue relating to ejectment itself. At that point in time, this present appeal was never filed. He instituted the second suit for specific performance.
The 2018 suit was for?
So 2018 suit was for ejectment, my second suit for ejectment. After
You said
termination.
he filed a suit in 2018 which came to be dismissed as.
He filed a suit in 2019, my lords, out of which the present appeal arises for specific performance. Both my suit for ejectment and his suit for specific performance
came to be adjudicated on the same day under two separate judgments. He filed an appeal as against the ejectment to the extent of the order of ejectment, contending that his right of specific performance is still available. And the clause says that I can keep on securing a renewal every 3 years. Every 5 years. I'm sorry, I stand correct. The division bench of this court, following the judgment of the Supreme Court, making the distinction between a renewal of the lease and an extension of the lease, said, where there is a provision for an extension, it automatically happens on the same terms and conditions. But where it is a renewal, you will have to prove that you are entitled to that renewal. Found against him on his conduct, 30 years I did not get rent. I had to pay more than 20 and odd lakhs towards taxes in respect to the property. It's a large property measuring an acre, situated in Mysore Road opposite RV College. He is squatting on the property. He is also related to me. He is my cousin's husband, squatting on the property. Then thereafter, my lords, my appeal came to be allowed to the extent of the payment of the taxes and the means property to respect to. 1 crore and odd is due by him today in terms of arrears of rent. His appeal challenging the ejectment came to be dismissed. To that limited extent, he is before the Supreme Court telling that he is not liable to be ejected. But that ends, my lord, or to some extent, insofar as the present High Court is concerned, a quietus has been laid in respect of that proceedings. Now, insofar as the present appeal is concerned, he suffered a judgment or degree of dismissal of his suit for specific performance on the ground that the period for which you are securing or seeking renewal has already elapsed. Before the present appeal could be filed, he immediately instituted one more suit for specific performance for the period from 2021 to 2026. I was not aware, I was not served with the summons. He did not take out notice for almost 1.5 years. Suit came to be dismissed for non-prosecution. Therefore, it is my submission. Having accepted the judgment of the trial court, instituted a second suit for specific performance for the subsequent period. Now, this appeal would not lie at the hands of this court. Court said your period is over. If you want for another period, if it is your contention that you are entitled to renewal successively every 5 years, please file another suit.
Then can you undertake or can you give in writing that in other litigations pending between you, you would not take any contention that lease period for the year from 2016 to 2021 was not renewed, would not be taken up by you? If you give that undertaking, then fine. This can be disposed of with one single sentence undertaking. Whether he is entitled for renewal for the current period, that both of you have to agitate. It is only to overcome the technical aspects. Unless this period.
Every aspect, my lords, is ultimately an aspect which decides a question. Technical or otherwise, it will still receive adjudication at the hands of the court. I am only submitting this. I have contested the suit not only on the ground that the suit is rendered infructuous, but also that he is not entitled to. But it was framed as a preliminary issue. He was given an option. He did not read evidence.
Fine. Two aspects. One, go on fighting in the matter. For decades it can go. Particularly in this case, if either of you minds, it can be ensured that for another 30 years the matter would not reach finality.
Now the suit for
Clear. It is openly that can be said. For another 30 years, either of you decide the matter can be continued in one court or the other without, say, ensuring any finality for that.
Therefore,
If you come and say, without prejudice your right to seek his eviction, without prejudice your right in other pending litigation, in order to overcome the technicalities, the renewal of the lease, the continuation of the possession from 2016 to 2021 during lease pendants would not be taken as non-renewal of the lease from 2016 to 2021.
No.
Then this litigation automatically goes.
No. I will only submit this. We may have to suffer another 30 years. I am aware that the
appeal is pending at the stage of admission. I am grateful that this court has given me an audience, but I am here only to ensure that judicial time is not wasted. If there is a proactive adjudication of the proceedings, it will not take 30 years. If the appeal is admitted, maybe it will take 30 years. But that does not necessarily mean that this court has to give him that right. I have produced just 4 documents. May I request this court to kindly see?
Yes, we will see to that
Because
at the relevant
because
stage.
at the time of admission, the court felt it needs these documents.
Yes, heard the submission of learned counsel for the appellant and learned counsel for the peruse the memorandum of appeal and the impugned order. Considering the grounds raised in the memorandum of appeal, which requires a detailed consideration, the appeal stands admitted. The appellant to file the paperwork within 4 weeks from today.
Yes.
Number 82.
Please. Yes, please.
There is no trial. There is only a plain written statement, issue and a judgment. All of which are already available on record. May I request paper books may be kindly dispensed?
Can we dispense it with both of you? Make any request?
I have already produced it. That is what I am trying to submit. It was at the instance of this court, I have already produced it on the 12th of April. There is nothing more to be. There is no evidence on record.
So, with respect to the paper book, he says that since the materials are very limited, the paper book can be dispensed with.
I have produced it, my lords. I am not saying
The
it is
paper book within 4 weeks and Pecuniary. I submitted. Since the original the impugned judgment is said to have been possible on preliminary issue and the trial court record has already been placed before the court and the counsel from both sides have got the certified copies of all the relevant documents to assist the court with the preparation and production of the paper book stands a dispensable. Yes.
Bill number 82.
For partition is pending. Respondent. Another suit for partition. In the parties is pending for consideration for the time. Partition. Not for the reason that they see. Divorce. Some complications are there.
This is a firm. This is a firm.
We will see.
Yes.
In this matter, say this much is only what I could hear and what. Yes.
Bill number 82. Ajit PB. Project.
What was the rent that was being paid? 15. 15. Have you paid the damages up to date?
Paid all the damages and the rents, my lord, and I've also submitted I've paid the damages and the rents up to date, my lords. I've also furnished the bank records in the along with my written statement, my lords. I've also furnished bank records to show that I've paid all the rents.
You paid the rent, not paid the damages.
According to you, how many months rent is still due?
No. No.
My lords, I've paid up to date rents.
You are the landlord, right?
Yes.
You admit that, say, up to date rent and the damages have been paid to you.
No, damages not paid.
Damages not paid. Have you paid damages up to date?
Instructions on the damages, my lords. I've been informed that damages and rent has been paid, my lords.
The building will, more than 80% of the rents is alternately vacated, except petition. You have to demolish.
So you want time today?
Tomorrow, my lords, it will be taken up tomorrow.
Council from 8%. List the matter in the week of next. As said. Week after next and the week after next birthday.
In a building demolished, alternately vacated, except the petition. More than 2 years in Europe.
Yes.
My lords, interim order may be extended.
Not extended. When you yourself is not sure whether the damages is paid or not, and the interim order was granted subject to you paying the damages up to date, you don't deserve any extension of interim order.
Because I paid the damages.
Yes. Now you don't insist for any particular date. Yes. Yes, next matter. Other arguments.
Lords, please may be taken up tomorrow, my lords.
No.
Or at least passed over.
Court has other matters. At your convenience, for lack of your instructions, the court cannot sacrifice the other matters. Yes.
Past over matters, serial number 4, Muniraju S, serial number 4.
Or again, second round, learned counsel for the appellant not present. In spite of getting this matter listed by specifically moving a memo for posting, the counsel for the learned counsel for the appellant has remained absent. Thus, he has not properly utilized the precious time of the court. Moreover, in spite of granting sufficient opportunities also, the appellant has not complied of his objection. This itself clearly go to show that the appellant is not interested either in prosecuting the matter or to comply of his objections. Accordingly, the appeal stands dismissed for non-compliance of office objection as well as for non-prosecution. Yes.
Serial number 45.
Counsel for KVT are present.
Serial number 45. Vivi Manjunath.
Called again. Counsel for the appellant neither present physically nor through video conference. On 26/5/2023, this court had made the following observation. Format in spite of granting sufficient opportunity 4 times. Dismissed non-compliance non-prosecution. Yes.
Bill number 46, Babu M.
It's not listed. Do this list. ಅದನ್ನ ಮತ್ತೆ ಸ್ವಲ್ಪ ಆಡ್ ಆಗಿದೆಯಲ್ರಿ ಆಗ್ಲಿಲ್ಲ. ಮತ್ತೆ ಒಂದೊಂದು. Called again. None appear in this matter either physically or through video conference. No reasons of forthcoming either for non-appearance of the direct counsel for the appellant or for non-compliance of office objection. The matter. Several sufficient opportunities of not less than 4 times have already been granted to the appellant, despite which the appellant is not evincing any interest prosecuting the matter and to comply the office objection. On 26/5/2023, this court had made the following observation. In spite of the above, the appellant, the learned counsel for the appellant has remained absent and office objection also have not been complied. On 22/5/2023 also, counsel for the appellant had remained absent, on which day, by making a detailed observation, this court had granted a final opportunity, despite which neutral had not been done. It appears that the very same learned counsel has remained absent in several other matters from 22/5/2023 to till date. At least in 6 regular first appeals, 4 got adjourned and 2 got dismissed. One on 23/5/2023, the other on 31/5/2023. Had there been any inconvenience for non-compliance of office objections, at least the learned counsel for the appellant could have appeared through video conferencing from wherever he is and made submission. A minimum attempt in that regard also has not been done. Hence, I do not find any further reason to grant any further time as such. The appeal stands dismissed for non-compliance of office objection as well as for non-prosecution. Number 66.
Seal number 66, Vijay AM, connected matters. First seal number 66, RFP number 1825 of 21.
Called again, learned counsel for the appellant is That also for appellant not present in RFA 1825/2021. Though the cause list shows that there is a non-compliance of office objection, however, the proceeding sheet endorsements put up with the registry does not mention as to what those office objections which are still due for compliance. Hence, registry 2 makes endorsement noting clear, detailed, and complete. Next.
RFA number 1176 of 2021.
God, I am requesting the respondent with the 17 and 18. I made the A number 7 of 2023. Seeking the temporary injunction against the appellants because they are alienating the item number 21 of the suit schedule property pending disposal of the appeal matter. And they have come up with the objection saying that in the trial court we are contesting the suit as suit is not maintainable. Accordingly, we are not entitled to the share or relief against the appellants. I produced the documents of failed deed matter along with my application.
The 7/20. Non-compliance of office objection. RFA 1176 of 2021. Learned counsel for the appellant not present. Learned counsel for respondent number 17 and 18. Alone is present. I submit that his IA 7/23 still pending consideration. Next time. Even in this appeal also, the registry has not mentioned in detail, mentioned completely, and not even the details as to which are all the office objections that are still to be complied with by the appellant in the main appeal. Registry to do needful in that regard.
Well, 66.3.
RFA 66.2, RFA 1914 of 2021. Venkatesh R. Bhagat.
RFA 1914 of 2021. None appear in this matter. Even in this appeal also, the registry has not completely mentioned or mailing the head about the office objections, etc., etc. Registry to do needful. In the meantime, 3 days time is granted to the appellant to take first steps by furnishing correct, complete, and present address of the unserved respondents number 19, 22, 24, and 25. Yes.
66.3, RFA 2021. KK Vasan.
But in case, for the year number 2 to 7 is concerned, I have to pay the process paid with the PD. The application is filed to bring a loss of respond number 9 and 20.
66.3 RFA 2000 of 2021. Learned counsel for the appellant alone present and for 3 days time to take first steps First step, to pay, process and furnish copies, etc. to issue notice to proposed LRs on IA 2 to 7 of 2023 and furnish fresh process, cover, acknowledgement, etc. to issue notice to respondent number 22 to 26.
One submission in that.
Yes, please.
One submission.
Please.
Early, Leela is appearing for respondent number 29, filed on right hand side.
Same party Gadra or Lidre, I would have directed him to take notice.
Of ತಗೊಂಡಿದ್ದಾರೆ notice ಅದು enter ಆಗಿದೆ.
ಯಾರಲ್ಲಿ ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟು?
Respondent 22 to 29. Leela for respondent number 22 29 ಅಂತ.
ಯಾವತ್ತವರೆಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಆಗಿದೆ?
Was ಹಿಂದೆ ಆಗಿದೆ accepted notice also.
ಹೌದ್ರಿ, ಒಂದು ಅದು ನೀವು ಹುಡುಕ್ಬೇಕು ಅಥವಾ ನಾನು ಹುಡುಕ್ಬೇಕು? ಬೆಟರ್ ಯೂಸ್ ಸರ್ಚ್ ಫಾರ್ ದಟ್. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗಿದೆ ಅಂತಾದ್ರೆ ಅವಾಗ ನೀವು ಇದನ್ನ ತಗೊಳ್ಳೋದು ಬೇಡ, steps ಬೇಡ ಆಗುತ್ತೆ.
Accepted served the copies also.
ಆಗ್ಲಿ, ಅದನ್ನು ಡೇಟ್ ಹೇಳಿದ್ರೆ ನಾನು ಇಮಿಡಿಯೇಟ್ ನೋಡಿ ಬಿಡ್ತೇನಲ್ಲ.
On 17 December 2022.
When Mr. Leeladhar was directed to accept notice for those respondents, I will see in the order sheet of the relevant date if you mention, so that I can make an observation in that regard. Ilde hodre steps anta hogutte.
12 December 2022.
ಏನೇನು ಕೊಡ್ತಿದ್ದೀರಿ, ಯಾವ್ದು ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ? ಈಗ 12th ಡಿಸೆಂಬರ್ ಅಂತಿದ್ದಾರೆ. 12th ಡಿಸೆಂಬರ್ ಇದರಲ್ಲಿ ಡಿಸೆಂಬರ್ ಆರ್ಡರ್ ಶೀಟ್ಗೆ ಡಿಸೆಂಬರ್ದ ಇಲ್ವೇ ಇಲ್ಲ. Really, to take first step from to issue notice to R 22 to 26 and 29 ಅಂತಿದೆಯಲ್ಲ, ಆ ಸೆಂಟೆನ್ಸ್ ತೆಗೀರಿ. ಅವ್ರು ಬರ್ಲಿ, ಬಂದಾಗ ನೋಡುವ. Time as ready is granted.
And so far as point number 30 is concerned, is alive.
13.
Our date on the
Which respondent?
respondent 30 30.
30. ಈಗ ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕಂತಿದ್ದೀರಿ?
Respondent number 31 is no more.
ರೆಸ್ಪಾಂಡೆಂಟ್ 30ಗೆ ಏನ್ ಮಾಡ್ಬೇಕಂತಿದ್ದೀರಿ?
I've taken steps. Date on the money, I've taken steps, she's alive.
ಅಲ್ಲ ವಕೀಲ್ರೆ, ಈಗ ನಮ್ಮಲ್ಲಿ ಪೋಸ್ಟಲ್ ಶರಾದಲ್ಲಿ ಡೆಡ್ ಅಂತ ಬಂದಿದೆ. ಆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೋರ್ಟ್ ಎದುರು ಇಲ್ಲ. ಆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಏನಾದ್ರೂ ಕೋರ್ಟ್ ಎದುರು ಬಂದಿದ್ರೆ ಥ್ರೂ ಅಡ್ವೊಕೇಟ್, ನಾವು ಈ ಪೋಸ್ಟಲ್ ಶರಾನ ಇಗ್ನೋರ್ ಮಾಡಬಹುದಿತ್ತು. ಈಗ ಪಾರ್ಟಿನೂ ಇಲ್ಲ, ಪಾರ್ಟಿ ಪರವಾಗಿ ಯಾವ ವಕೀಲರು ಇಲ್ಲ, ಪೋಸ್ಟಲ್ ಶರ ಇದೆ. ಹಾಗಿದ್ದಾಗ ನೀವು ಕೇವಲ ಮೌಖಿಕವಾಗಿ ಯಾಕೆ ಬದುಕಿದಾಳೆ ಸ್ವಾಮಿ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ?
I will take necessary steps. I will
ಅದನ್ನ
see.
ಹೇಳ್ಬೇಕು. ಯಾವತ್ತು ವಾಕ್ಯನ ವಕೀಲರುಗಳು ಪೂರ್ತಿ ಮಾಡ್ಬೇಕು. ಅರ್ಧ ಹೇಳೋದಕ್ಕೆ ಏನ್ ಪರಿಹಾರ ಅದನ್ನ ಕೋರ್ಟೇ ಹೇಳಿ ಅಂತ ಮಾಡಬಾರ್ದು.
I will like, do the.
The learned counsel for the appellant further submits that though the postal shara on the returned notice sent to respondent number 30, Srimati Ratnam, mentions that she is dead. However, according to information given to him by the appellant, she is still alive, and that he would do needful in the matter as per law. Yes. Any other submission?
Four.
Huh.
See, that four is concerned on one of the. Number four. Otherly,
Huh.
appellant number 2 died. And I filed the application to bring her a loss on record and also an application to order 2229. There are two applications.
Now, first question preliminary. Are there any office objection due for complaints in the main memorandum of appeal in this matter?
ಇಲ್ಲ, ಏನಿಲ್ಲ.
Yenilla.
But after filing the appeal, the respondent by appellant number 2 died.
So according to you, there are no office objection for complaints on the main appeal?
And ಯಾವ್ದು ಇಲ್ಲ.
Illa. Fine. Then IA 1/22 for setting aside the abatement with respect to the deceased appellant number 2. ಎಲ್ಲಿದೆ IA 1/22?
ಅಯ್ಯಪ್ಪ.
The learned counsel for the appellant submits that there are no office objection on the main memorandum of appeal to be complied in this appeal by the appellants. As such, the matter can be proceeded further. Such submission is taken on record. Next line. Appellant number 2, Srimati Rajamma,
Yes.
died according to you.
On 8/5/2022 died. I filed application. On 12/8/2022 I filed application.
That application is only for seeking setting aside of the abatement.
ಇನ್ನೊಂದಿದೆ to bring a loss on record of. IA number 2/22.
Figure IA 2/22. Before considering these two IAs, is it not required that all the respondents who have remained unserved are required to be served first?
I have made service on some of the respondents. 22.
So therefore, these IAs cannot show any progress or cannot be taken up for consideration until the respondents in the main appeal are served. You first ensure the service of notice upon the respondents as observed above. Yes. As such, the matter could not be proceeded further today. Yeah. Whom you care for? 87.
Yes.
At the request of the learned counsel for the appellant. RFA 1653.
Yes.
Because of the land transfer for the applicant, a week's time as credit is granted. Yes.
Hello, court officer. Sir, court officer.
ಸರ್ ಹೇಳಿ ಸರ್.
Serial number 20 ಏನಾಯ್ತು ಸರ್?
ಅರ್ಜುನ್ ಆಗಿದೆ.
ಎಷ್ಟು ದಿನ ಸರ್?
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದಿ.
ಓಕೆ ಸರ್, ಓಕೆ. ಹಾ ಸರ್ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಹಾ ಹಾ ಅಲ್ಲ ಮಿಕ್ಸ್ಕಲ್ಲ ಈಗ ನಾಳೆ ನಾಡ್ದು ಮಾಡ್ಬೇಕು ಮಂಡ್ಯ ಒಳಗೆ ಮಾಡ್ಬೇಕು ಅದನ್ನ ಹಾ ಇಲ್ಲ ಸರ್ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ ಇಲ್ಲಿ ಆಫೀಸಿಗೆ ಬಂದಿದ್ದೀನಿ ಹಾ 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 ಆಫೀಸಲ್ಲೇ ಇರ್ತೀನಿ ನಾನು ಆಯ್ತು 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 ಓಕೆ ಓಕೆ
ಸರ್ ನಿಮ್ದು ಯಾವ್ದು ಸರ್ ಮ್ಯಾಟ್ರು? ಹಲೋ
ಏ?
ಸರ್ ನಿಮ್ದೇನು ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ?
ಇದೇ ಇತ್ತು ಸರ್, ಒಂದು NOC ಹಾಕಿದ್ವಿ.
ಎಷ್ಟಿದೆ ಸರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 87.
ಸರ್ 87 ಬೆಳಗ್ಗೆ ಡೇಟ್ ತಗೊಂಡ್ರಲ್ಲ ಸರ್? ಅಲ್ಲ
Date ತಗೊಂಡ್ರಾ?
ಒಂದೂವರೆಗೆ ಯಾರು ಡೇಟ್ ತಗೊಂಡ್ರು ಟೈಮ್?
ಓಕೆ ಸರ್, ಓಕೆ
ಎ ವೀಕ್ಸ್ ಟೈಮ್ ಗ್ರಾಂಟೆಡ್.
ಓಕೆ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಯಾವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್?
20ನಾ?
ಹಾ,
ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಯಾವ್ದೋ ರಾಜೇಂದ್ರ MS ಅಂತ ಇದೆ.
ಹೌದು.
ಅದು 16/6 ಸರ್.
ಓಕೆ ಸರ್, ಓಕೆ.
1 week to comply office objection.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಅಲ್ಲ ನೀವು 5% ಏನಿಲ್ಲ ಡಿಸ್ಪೋಸ್ ಒಂದು ಎಂಟ್ರಿ ಮಾಡಿ ಅಂತ.
ಸರ್ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಅಷ್ಟೇ ಸರ್ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಹೋದ್ರೆ ಊರಿಗೆ ಅಂತಾನೆ
Yes.
Bill number 65, Murthy K.
Yes, please.
Respondents underrepresented. My reverse ballot, requesting the court to consider my application IN number 1 of 2023. And my suit for declaration, possession dismissed. Suit is in respect of 10 guntas of land by law.
Mr. Counsel, before proceeding with IA 1/2023, the service of notice upon the unserved respondent is required to be completed.
Really. As per
The
the law.
emergent notice were ordered and you are yet to take step. Ensure the service of notice upon the unserved respondents. You will proceed with the matter without any delay.
Notice is duly served as per the, I have taken the track sheet, my lord. It is duly served, my lord, on respondent number 1 and 4. Also, respondent number 2 and 3 on 15/4/2023 and 17/4/2023, my lord. Yeah, I can read this. Even I moved before the honorable vacation bench also, my lord, because of urgency. I made my best efforts, even in the office also. I've taken, this is the report, my lord.
Mr. Counsel,
Yes.
those things they have to agitate before the registrar, not in the court. If there is any, say, the overlooking of that, or if that has been, say, escaped from their notice, they will rectify it. We cannot see that photocopy and say, and hold that say notice has been served. It is for them to do it. There is a specific instruction for them to do it. I do not know. In some cases they do, and some cases they do not do. But they have written a different shara. They have shown some reason that with a particular post in the shara, the notices have been written. When the notices have been written, where is the question of, say, the delivery? Because the actual physical copy of the notice would be the registry.
Is written as unclaimed. Respondent number 2 and 3 is concerned. It is written with a shara that unclaimed. And 1 and 4.
Sir, I am speaking about unserved respondents, that is respondent number 1 and 4.
As per the office note, my lord. Yes, my lord, I will take steps as against respondent 1 and 4. But, my lord, as on the date of filing the suit in 2012, the property was vacant. My suit dismissed only on the ground that the partition deed referred by the plaintiff not produced before the trial court. Only on that ground, the suit dismissed, my lord. So now I am seeking possession and declaration, my lord. So now in March 2023, they started putting up construction, especially the respondent number 2 and 3 here, who both husband and wife, my lord. They started putting up construction and they are trying to produce the photographs along with the application, my lord. So to that extent, my lord, because my client is 87 plus and he's a handicapped person, and the suit is dismissed only on this ground. Now I have produced the partition deed along with the application.
On the previous occasions, the previous roasters, probably after hearing you completely, have ordered for issuance of emergent notice. IAs are kept pending. Even the cause list also doesn't show that couple of respondents have been served and they are being represented by counsel.
No, my lord.
Now, that being the case, when an emergent notice is ordered both on the appeal as well on the IA, without the service of notice, the court cannot go. You should expedite the matter in a faster manner, how best you can. Ensure the service of notice. You can do that. Despite the service of notice, if they remain unrepresented, fine. They face the consequences, for which you need not have to bother. But at least there must be a service of notice to them.
Please, as against the served respondent, my lord, 2 and 3, they are only the putting up of proceeding with the construction. They are unclaimed, it is written. Now I'll take steps, my lord, by today itself against 1 and 4. At least I pray, humble prayer, my lord, because if they proceed with the construction, my lord. They started in March 2024. I also moved before the vacation bench, my lord.
The office note also shows that the steps are not taken even as against respondent number 2 and 3.
Even this, as of today, it shows it is unclaimed.
Not unclaimed, steps not taken, they have written.
But none about the sheep.
ನೀವು ಅದನ್ನ ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳ್ಬೇಕು. ಇಲ್ಲಿ ಅವರು ಬರೆದು ಕಳಿಸಿರೋದು ಸ್ಟೆಪ್ಸ್ ನಾಟ್ ಟೇಕನ್ ಆರ್ 2 and 3. ಅದೇನಾದ್ರು ತಪ್ಪಿದೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗಿ ಕೇಳಿ, ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಎದುರುಗಡೆ ನಿಂತು ಕೇಳಿ, ಇದನ್ನ ಯಾಕೆ ಬರೆಸಿದ್ದೀರಿ, ಸೆಟ್ರೈಟ್ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೂ ಮೀರಿ ಅವ್ರು ಬೇರೆ ಏನಾದ್ರು ಅನ್ಅಕ್ಸೆಪ್ಟಬಲ್ ರೀಸನ್ ಕೊಟ್ರೆ ಅವಾಗ ಬನ್ನಿ, ಅವಾಗ ನಾವು ಬರೆಯುವ.
Till then, at least none to protect my property, some order to on IN number some order, my lord. Till then,
ನೀವು ಬೇಕಾದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕೆ ಕೇಳಿ, ನಾನು ತಾರೀಕು ಕೊಡಬಲ್ಲೆ, ಬಟ್ ಅಲ್ಲಿ ಅಷ್ಟರೊಳಗೆ ನೀವು ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಎನ್ಶೂರ್ ಮಾಡಿ.
my lord, I may be permitted to serve, take out notice on the council appearing in the trial court.
No, only after you could not say effectively serve upon them here. Merely by asking the same cannot be granted.
Both to the respondents as well as on council. Otherwise, great hardship would be caused to the applicant.
Assuming for a moment that you take notice on the council, do you think that this notice on the council can be a valid and complete service on the litigant?
Both more.
ಅಲ್ವೇ? ನಿಮಗೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆದ್ರೂ ನೀವು ಬಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ? ನೋಟಿಸ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದನ್ನ ತಗೊಳ್ತೀರಿ, ಅದನ್ನಲ್ಲೇ ಬಿಡ್ತೀರಿ ಅಷ್ಟೇ. ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಏನಿದೆ ನಿಮಗೆ ಅಕೌಂಟಬಿಲಿಟಿ? ಮತ್ತೆ ಗೊತ್ತಿರ್ತದೆ, ಇಟ್ ವುಡ್ ಬಿ ಎ ಫ್ಯೂಟೈಲ್ ಎಕ್ಸರ್ಸೈಸ್ ಅನ್ನೋದು ಗೊತ್ತಿರ್ತದೆ. ಆದ್ರೂ ಒಂದು ಸ್ಟೇಕ್ ಮಾಡ್ತೀವಿ. ಯಾವ ಡೇಟ್ ಬೇಕು ಕೊಡುವ, ನಿಮಗೆ ಅದು ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ನೀವು ಮುಂಚೆ ಕೇಳ್ಬೇಕಿತ್ತು. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆನ್ ಮೇನ್ ಅಂಡ್ ಐ ಅಂತ ಆಗಿರೋದ್ರಿಂದ ಐ ಕ್ಯಾನಾಟ್ ಡಿವೇಟ್ ದಟ್ ಆರ್ಡರ್ ನೌ. ದ ರಿಜಿಸ್ಟ್ರಿ ಸೇಸ್ steps not taken in respect of R2 and R3. R1 returned with insufficient address. R4 addressee left. That is the shara. ಶರ ಬರ್ದಿರ್ಲಿಲ್ಲ, ಬೆಳಗ್ಗೆ ಮ್ಯಾಟರ್ ಕಟ್ ಬೈ ಮಾಡಿ ಬರೀಲಿಕ್ಕೆ ಕಳಿಸಿದ್ರು, ಬರೆದು ಕಳಿಸಿದ್ರು. The position as in the afternoon.
Take proper steps in 2 days, but till then, some orders on IN number.
ಇಲ್ಲ, you are wasting the time of the court and testing the patience of the court. ಇಷ್ಟೊತ್ತಿನ ಸಮಾಧಾನದಲ್ಲಿ ಹೇಳಿದೆ,
Grant me 2 days.
ವಿಧ ವಿಧದಲ್ಲಿ ಹೇಳಿದೆ. Yes, learned counsel for the appellant. Place for 2 days time to do needful in the matter to ensure the service of notice upon unserved respondents. The time as paid is granted. Serial number 68.
GM Anand, I will come. I informed Mr. GM Anand, who is appearing for the BDA, and I have served the copy to him.
Lord, last occasion, Lord, I received the copies and I forwarded to my Lord, the BDA office. So I have not received any intimation so far. I'll get the instruction and I'll make.
The submission called again, learned counsel for the appellant. Physically present. Heard his submission. There is a memorandum of appeal in the improved order issued. Emergent notice to the respondents. Learned counsel Sri GM Anand, who is appearing to video conference, submits that he has been served. He is a panel advocate for respondent number 1, 2, and 3, and that he has received copy of the memo of appeal with annexures from the counsel for the appellant, and that as such he would accept the notice for respondent number 1, 2, and 3. He is permitted to take notice for respondent number 1, 2, and 3. He is granted a week's time to file wakalat for respondents and objection if any to the pending IAs. Yes.
Please, publish.
Other arguments, bill number 83, Srimati Veena Kumari M, T. Srinivasan.
Yes.
On the last day. I had already submitted the contradictions in the examination in chief itself. of the PW 1, 2, and 3. Even with regard to how the alleged talks took place and the, whether the defendant approached the plaintiff or the plaintiff approached the defendant and such, which may or may not be of much consequence, but it will be consequential in the light of the very agreement itself, which I had submitted, was shrouded in mist, because the date of the agreement is 5/9/12, whereas it is said to be executed on 27/3/13. Now, the PW1 says that it was executed on 5/9/12 itself, that it was typed out on 5/9/12 itself. Whereas PW2 and 3 say it is not so, it was on 27/3/13. And the PW3 is the advocate who says, I drafted it. He says, I was approached in the court, and in the court, I did the need. I will not take this court through the entire cross-examination because the chief itself has done enough time. Except to say that the place where it was prepared and typed also in the cross-examination of PW2 and 3, there are serious contradictions. The PW3 who says that he drafted it itself gives the go-by in cross-examination where he says it was there earlier, the date was changed. Where I am leading to on that issue, my lord, is again connected with the question of the 3-month period. No doubt in cross-examination of the defendant, as I said, he shook his head for everything and he admits his signature there, he admits having received the money. Now, right from the through the evidence, the notices issued, the agreement itself, they are all in agreement of this one aspect. That within 3 months, the balance amount had to be paid and the sale deed executed. Failing which, the plaintiff was entitled to a refund of the amount. Now, the trial court has dealt with the issue of the refund of that amount by saying that I should have told him, come and take the refund. And because I have not told him, come and take your refund, I have forfeited that option. And therefore, I am bound to execute the sale. With respect, I believe that may not be the correct position. Because, as I did point out earlier, no doubt the decision in Moranmar, the Catholicos, and the Vasavi Cooperative Society were all pertaining to suits for declaration and possession. But that is the position of law when it comes to any suit that is filed by anybody. It is for the plaintiff to stand on his own feet and to prove this case. In the case of a suit for declaration and possession, the burden on the plaintiff to prove it would be almost like proof in a criminal case. Whereas in all other suits, preponderance of probability would be there. Here, my lord, in every exhibit, every notice that is issued, ITC, my lord, exhibit B48. B4. I would like to point out just two things here. One is the date, 10/10/2013, and paragraph 2.
Exhibit
P4A.
yes.
The date of the notice is 10/10/2013. one thing I want. The other thing is on the same page, paragraph 2. The last few lines.
Yes.
4, 5, 5th line. Or the 6th line. Agreed to execute the relevant registered sale deed in favor of our client within 3 months from the date of execution of the sale agreement by receiving so and so. So that 3 months is admitted. And this, my lord, is the first notice issue in October of 13. In exhibit P5, in exhibit P5, which is 23/6/2014, paragraph 2, again the same things. Registered sale deed in favor of our client within 3 months from the date of execution of the sale agreement by receiving balance sale. Exhibit P6 in the same date, again the same thing. This exhibit P1 by page 3 of the document. It begins at the last paragraph of page 2, where it again says the last part one line. Within a period of 3 months from the date of execution of this agreement. From there, I take my lord to the next page. That very clearly says what should happen with regard to the second paragraph on the next page. Whereas the vendor agreed to execute so and so within the stipulated period as stated above by receiving the balance consideration. And then the next paragraph. Whereas if he fails to execute the regular registered sale deed in favor of the purchaser is at liberty to approach the court of law for execution of the document dated registered at the cost of the vendor. So also, if the purchaser fails to pay the balance sale consideration amount within the stipulated period, the advance amount will be refunded for the purchaser. This part of it. So also if the purchaser fails to pay the balance sale consideration within the stipulated period, the advance amount will be refunded for the purchaser. He is not by any stretch of imagination the burden on the vendor to say, you have not paid, take your money back. The burden is on the purchaser. He should have said, look, since I have not paid you the money within the 3 months, give me back money. I am entitled. It doesn't say so. Therefore, I submitted with respect to the conclusion of the trial court that I should have told him, since you have not paid, come and take your money. May not be correct in the light of the specific clause here in Exhibit B1. Further, my lord, this agreement is well before 2019. Therefore, the court had discretion. It could have said, no, we are not ordering specific performance. We are giving you back your agreements post 2019 would be hit by the amendment order. But here the suit also is of the year. The suit is also well before that, it is of the year 2014.
Yes.
My lord. On these aspects also would question the very authenticity of the document. As I said, it is shown in the list. Merely because I admit the signature there, merely because I have admitted receipt of 10 lakhs, does not take away from the doubt cast on the document. Because the plaintiff who had to prove his case and his witnesses, including the person who drafted it, are not sure about when it was done. There are serious contradictions there. Now, why would that have been done? The answer would lie in this aspect, namely that 3 months was the time. So they have noticed that it is of the year 2013. So they changed the date. He has obviously impacted plain perusal of the signature would show that it is not his signature, but he has admitted. Therefore, I cannot press that point before this court because what is admitted is not true. But kindly see here, my lord, even in his evidence, besides the pleadings of the plaintiff itself and all those exhibits, at paragraph 3, the PW1 is very clear about it. At the bottom of that, the exhibits agreed to receive the balance sale consideration. Sorry.
PW1, cross-examination.
No,
G.
I will not take my lords through the cross-examination because they have
Yes.
done my work in the chief.
Yes.
Here too, there is an admission.
Yes.
Agreed to receive the balance sale consideration amount, a sum of rupees 4 lakhs within a period of 3 months from the date of execution of the agreement of sale, wherein the defendant also put his signature for the correction of the date of the agreement of sale. The original agreement of sale is produced. Then he goes on to say, I submit that as per the terms and conditions of agreement of sale, I am repeatedly demanding the defendant to come to KGF and execute the registered sale deed in my favor by receiving the balance sale consideration amount. But the defendant wantonly and willfully postponing the date on one way or the other and failed to perform, though I am ready and willing to perform my part of contract as per terms. My lord, this is an important aspect because it is the plaintiff has to prove his readiness and willingness at every point. So he makes a statement, about his readiness and willingness. But there is no material to show that he was ready. Absolutely not.
What material you were expecting or anticipated?
For one thing, a simple statement at least saying, please come and execute it. He says, I told him repeatedly, but I will show from his next sentence that it cannot be true. Because he says, as such, no other way to go. I issued a legal demand notice to the defendant on 10/1/2014 by way of registered post. To the address mentioned in the agreement of sale, the said legal as addressee left without intimation, hence returned to the center. Again, with great difficulty, I found out the address. Now, if he knew that he was in Bangalore, whom was he demanding the execution of the sale deal from? He issues a notice. He is a tenant in the same premises. He issues a notice to me, knowing that I am not. And he says he was regularly demanding. If he was regularly demanding from me in Bangalore, because I was not in Kolam, not in KG. So if his examination in chief is to be believed, he was probably standing in front of my building and shouting at the building every day, expecting that the echo will reach Bangalore. That cannot be believed. Therefore, the readiness and willingness are not there. Even the PW2, he says that with great difficulty, he found out the address in Bangalore and came to Bangalore and said, come and register the document. Evidence of PW2. In the examination, I submit that the plaintiff approached me and expressed that the defendant is not executed the registered sale deed in his favor, even after repeated demand and request, though the plaintiff is ready to pay the balance sale. I approached the defendant at Bangalore, where himself and his wife were residing independently. The defendant agreed to execute the registered sale deed, but he fails to do so, hence the plaintiff filed the above case. He does not say when he went there, but he too says the time fixed was 3 months, and he says that he finally came to Bangalore. There is a question of the plaintiff coming to Bangalore making demands. It is the PW2 who, according to them, eventually found out where I was in Bangalore and came to Bangalore. Therefore, the readiness and willingness is definitely not there by any stretch of it. It is also his case that the first notice he issued was only in 2013 as per Exhibit 4A. If there is anything, I will, in reply, I will say, because otherwise I'll be repeating this. Just the last two things I wanted to point out was that we are ready to refund the money even now with interest as the 4%. And if they are, because as it stands, they are old, and 2 daughters, one of them is no more. So they have practically moved to Bangalore now, and this is in terms of compromise and so making this last submission, that they are moved here to take care of those children now. The husband is no longer with those children, so they are there. So if they're willing to pay the current market value, that compromise could be worked out, but That's not part of my arguments, my lord, otherwise they will hold me.
Yes.
In fact, in saying that para 10. I stated the correct events as to how the transaction came about. Regarding cause of action for this transaction. Cause of action, I have stated now. The cause of action arose on 5/9/2012 when the negotiations took place, and on 7/3/2012 when the defendant, that is actually it is 2013, but it is a typographical, it's 2013. When the defendant executed and signed the agreement of sale after receipt of ₹10 lakhs as advance on 10/10/2013, 26/6/2014, when the plaintiff issued legal notice to RPID to the defendant, and on 12/7/2000, when the plaintiff issued remainder legal notice to the defendant through professional courier, and subsequently within the jurisdiction of the Honorable Court. Here it's clearly narrated that negotiations took place on 5/9/2012, and the transaction as such took place on 7/3/2013. And the advance amount of 10 lakhs was paid on that day. Even for that matter, the defendant in his written statement, paragraph number 14, he says that he understands that the transaction has taken place on 27/3/2013, and accordingly, what he says is the defendant further submits that the defendant had no intention to sell the suitable property in favor of the plaintiff, and the said alleged transaction as contained with the plaintiff said to have been executed on 27/3/2013 is a forged one, and no consideration has passed by virtue of the alleged agreement of sale dated 27/3/2013. He very much refers to this transaction as 27/3/2013. Also, in the cross-examination of PW1, there is no dispute as to the amount being paid on 5/9/2012 or on 27/3/2013. In fact, PW1 in his evidence, he clearly admits about these aspects. As to when he received the money, page 61, PW1's cross-examination. Cross-examination PW1. ನಾನು ಗಣಿ ನಿರ್ದೇಶನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಿರಿಯ ಸಹಾಯಕನಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿ 2001ರಲ್ಲಿ ನಿವೃತ್ತಿವಾಗಿರುತ್ತೇನೆ. ಬೆಂಗಳೂರು ಮನೆ ಕಟ್ಟಿರುವ ಸಲುವಾಗಿ ದಾವಾ ಸ್ವತ್ತನ್ನು ಮಾರಾಟ ಮಾಡಲು ವಾದಿಯೊಂದಿಗೆ ಒಪ್ಪಂದ ಮಾಡಿಕೊಂಡಿದ್ದೆ. ನಿಶಾನೆ P1 ಅಂತೆ ನಾನು ವಾದಿಯೊಂದಿಗೆ ಒಪ್ಪಂದದ ಮಾಡಿಕೊಂಡು ನಿಶಾನೆ P1ರಲ್ಲಿ ಕಾಣಿಸುವ ನಿಶಾನೆ P1A ಇಂದ ಈ ರುಜುಗಳನ್ನು ರುಜುಗಳಾಗಿದೆ. ನಿಶಾನೆ P1 ಅನ್ನು ತಯಾರಿಸಿ ಚಾಪಾ ಕಾಗದ ದಿನಾಂಕ 5/9 ಖರೀದಿಸಿ ಮಾಡಲಾಗಿದೆ. He says that he admits that on 5/9 ಚಾಪಾ ಕಾಗದ ಖರೀದಿ ಆಗಿರೋದು ಅಂತ ಮಾಡಲಾಗಿದೆ. ನಿಶಾನೆ P1 ದಾಖಲೆಗೆ ದಿನಾಂಕ 27/3/2013 ರುಜು ಮಾಡಿರುತ್ತೇನೆ. ನಿಶಾನೆ P1ರಲ್ಲಿರುವ ದಿನಾಂಕವನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿ ಬರೆಯಲಾಗಿದೆ. ಅದಕ್ಕೆ ರುಜು ಸಹ ನಾನು ಮಾಡಿದ್ದೇನೆ. Even the correction he has attested the correction as such. ನಿಶಾನ P1ರಲ್ಲಿ ನನ್ನ ಅಳಿಯನಾದ ದೀಪ್ತಾ ಅವರು ನಿಶಾನ P1 ರುಜು ಮಾಡಿರುತ್ತಾರೆ. Ishan, even his son-in-law is a signatory to exhibit P1. He admits that aspect also. ರುಜುವು ಮಾಡಿರುತ್ತಾರೆ. ವಾದಿ ನಿಶಾನೆ P1 ಅನ್ನು ಟೈಪ್ ಮಾಡಿದ ತಂದಿರುತ್ತಾರೆ. ನಿಶಾನೆ P1 ರಲ್ಲಿ ನಾನು ರುಜು ಮಾಡಿದ ನಂತರ ಜಿ ಮನಿ ವಕೀಲರು ರುಜು ಮಾಡಿ ನೀವು ಸೀಲು ಹಾಕಿರುತ್ತಾರೆ. ನಿಶಾನೆ P1 ರಲ್ಲಿ 3 ತಿಂಗಳು ಒಳಗೆ ಖರೀದಿ ಪತ್ರ ಬರೆದು ಕೊಡಬೇಕೆಂದು ಮಾತಾಗಿದ್ದು, ನಿಶಾನೆ P1 ರಲ್ಲಿ ಕಾಣಿಸಿರುವ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ತಫ್ಸೀಲು ಸರಿ ಇರುತ್ತೆ. ನಿಶಾನೆ P1 ರಲ್ಲಿ ಕ್ರಯದ ಪತ್ರವನ್ನು 14 ಲಕ್ಷ ಎಂದು ಒಪ್ಪಿರುತ್ತೇವೆ. ನಾನು 10 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಅದು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ, 10 ಲಕ್ಷ ನಾನು ಪಡ್ಕೊಂಡಿದ್ದೇನೆ ಅಂತ. ಉಳಿದ 4 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಕ್ರಯ ಪತ್ರ ನೋಂದಣಿ ಮಾಡುವ ಕಾಲಕ್ಕೆ ಕೊಡಬೇಕಂತೂ ಮಾತುಕತೆ ಆಯಿತು. He also admits at the time of registration of the sale, the balance sale consideration needs to be paid. ನಿಶಾನೆ P1 ಪುಟ 3 ರಲ್ಲಿ 3ನೇ ಪ್ಯಾರಾದಲ್ಲಿ ಒಂದು ವೇಳೆ ಮಾರಾಟ ಆಗಿರುವ ಕ್ರಯ ಪತ್ರ ಬರೆಸಿ ನೋಂದಾಯಿಸಿ ಕೊಡಲು ವಿಫಲರಾದರಲ್ಲಿ ಖರೀದಿಸುವ ನ್ಯಾಯಾಲಯದ ಮೂಲಕ ಮಾರಾಟಗಾರರ ಖರ್ಚಿನಲ್ಲಿ ಖರೀದಿ ಪತ್ರವನ್ನು ನೋಂದಾಯಿಸಿಕೊಡುವುದು ಎಂದು ತಿಳಿಸಿದೆ ಎಂದರೆ ಸರಿ. ಬೆಂಗಳೂರಿನಲ್ಲಿ ನನ್ನ ಸಮಸ್ಯೆ ಬಗೆಹರಿಯದ ಕಾರಣ ನಾನು ವಾದಿಗೆ ಕ್ರಯ ಪತ್ರ ಬರೆದು ನೋಂದಾಯಿಸಿಕೊಡಲು ಆಗಿರಲಿಲ್ಲ. He explained what is the reason for not executing the sale in favor of the plaintiff also. ನನಗೆ ವಾದಿ ನಿಶಾನೆ P2 ರಂತೆ ನೋಟಿಸ್ ಕಳಿಸಿರುತ್ತಾರೆ. ನನಗೆ ನೋಟಿಸ್ ಬೆಂಗಳೂರು ವಿಳಾಸಕ್ಕೆ ಜಾರಿಯಾಗಿದೆ. ನಾನು ಸದರಿ ನೋಟಿಸ್ಗೆ ಜವಾಬು ಕಳಿಸಿಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿನ ಅಸಲು ಕ್ರಯ ಪತ್ರವನ್ನು ನನ್ನ ಬಳಿ ಇರಿಸಿಕೊಂಡು ಜೆರಾಕ್ಸ್ ಪತ್ರವನ್ನು ವಾದಿಗೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಕ್ರಯ ಪತ್ರ ನೋಂದಾಣುವಾಗ ಅಸಲು ಕ್ರಯ ಪತ್ರವನ್ನು ವಾದಿಗೆ ಕೊಡಬೇಕು ಮಾತಾಗಿತ್ತು. ವಾದಿ 4 ಲಕ್ಷ ರೂಪಾಯಿ ಬಾಕಿ ಹಣವನ್ನು ಪಾವತಿ ಮಾಡಿ ಕ್ರಯಪತ್ರವನ್ನು ನೋಂದಾಯಿಸಿಕೊಳ್ಳಲು ತಯಾರಿದ್ದಾರೆ ಎಂಬ ಸಲಹೆಗೆ ಸಾಕ್ಷಿ ನನ್ನ ಕೌಟುಂಬಿಕ ಪರಿಸ್ಥಿತಿ ಸರಿಯಿಲ್ಲದಾದ ಕಾರಣ ನಾನು ದಾವಾ ಸ್ವತ್ತಿನ ವಾಸಕ್ಕೆ ಬರಬೇಕಂತ ಉದ್ದೇಶ ವಿರುದ್ಧ ಕಾರಣ ಕ್ರಯಪತ್ರವನ್ನು ನೋಂದಣಿ ಮಾಡಿಕೊಡಲು ಸಾಧ್ಯವಿಲ್ಲ ಅಂತ ನೋಡಿದಿರುತ್ತಾರೆ. ಈ ಸೇಸ್ ಅವ್ರು ರೆಡಿ ಆಗಿದ್ರು ಕ್ರಯಪತ್ರ ನೀವು ಬರ್ಕೊಳ್ಳಿ ಅಂತ ಇಲ್ಲ, ನಾನು ಅಲ್ಲಿ ವಾಸ ಇರ್ಬೇಕಂತ ನಾನು ಇಚ್ಛೆ ಪಡ್ತಾ ಇದ್ದೀನಿ, ಅದರಿಂದ ಈ ಅಮೌಂಟ್ ತಗೊಳ್ಳಿಲ್ಲ. ನಾನು ಈ ವೆರಿ ಮಚ್ ಸೇಸ್ ದಟ್ ಆಸ್ಪೆಕ್ಟ್ ಆಲ್ಸೋ ಇನ್ ಹಿಸ್ ಎವಿಡೆನ್ಸ್. ನಾನು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಮನೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಕೇಬಲ್ ರವಿ ಅವರ ಮನೆ ಬಳಿ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಈ ವಿಳಾಸದಲ್ಲಿ ಲೀಸ್ ಮಾಡಿಕೊಂಡು ವಾಸವಿದ್ದೇನೆ. ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ಬುದ್ಧರಾಜ್ ಹಾಗೂ ವಸಂತರಾಜ್. ಮತ್ತೆ ಕಮಿಂಗ್ ಟು ದ ಲಾಸ್ಟ್ 2 ಲೈನ್ಸ್, ವಾದಿ ನೋಟಿಸ್ ಕಳಿಸಿರುವ ನಾನು ಕ್ರಯಪತ್ರವನ್ನು ಮಾಡಿದ್ದ ಕಾರಣ ಈ ದಾವಾ ಸಲ್ಲಿಸಿದ್ದಾರೆ ಎಂದು ಸಾಕ್ಷಿ ನಾನು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಸೆಟಲ್ ಆಗಿದ್ದ ಕಾರಣ ಕ್ರಯಪತ್ರ ಮಾಡಿಕೊಳ್ಳಲು ಆಗೋದಿಲ್ಲ ಅಂತ ನೋಡಿದಿರುತ್ತಾರೆ. ಬೆಂಗಳೂರಲ್ಲಿ ನಾನು ಸೆಟಲ್ ಆಗಿದ್ದೀನಿ, ನಾವು ರೆಡಿ ಇದ್ದೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ನಾನು ಬೆಂಗಳೂರಲ್ಲಿ ಸೆಟಲ್ ಆಗಿದ್ದೀನಿ, ಅದರಿಂದ ನಾನು ಈ ಕ್ರಯಪತ್ರ ಮಾಡ್ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ದಟ್ ಈಸ್ ವಾಟ್ ಹಿ ಸೇಸ್.
ಓದಿ ಇನ್ನೊಮ್ಮೆ ಸೆಟ್ಲ್ ಆಗಿದ್ದೀನಿ ಅಂತಾರ, ಆಗಿಲ್ಲ ಅಂತಾರ.
ಏನ್ ಸರ್?
ಬೆಂಗಳೂರಿನಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದ್ದೀನಿ ಅದಕ್ಕೆ ಮಾಡಿ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ. ಸೆಟಲ್ ಆಗಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ದಾರೋ ಅಥವಾ ಸೆಟಲ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೋ ನೋಡಿ.
ವಾದಿ ನೋಟಿಸ್ ಕಳಿಸಿದ್ದ ನಾನು ಕ್ರಯಪತ್ರವನ್ನು ಮಾಡಿಕೊಡುವ ಕಾರಣ ಈ ದಾವೆ ಸಲ್ಲಿಸಿದ ಸಾಕ್ಷಿ ನಾನು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಸೆಟಲ್ ಆದ ಕಾರಣ ಸರಿ ಕ್ರಯಪತ್ರ ಮಾಡಿಕೊಂಡು ಆಗುವುದಿಲ್ಲ ಅಂತ ನೋಡಿದಿರು. That is what he contends. Here from this evidence of the defendant number 1, it is clear that the sale talks took place on 5/9/2012. Agreement of sale was executed on 27/3/2013. He didn't come forward to execute the sale deal in spite of repeated demands. Even in my notice for that matter, I stated in paragraph number 4 of my notice, the demand made by me exhibit P2 it is done that in spite of repeated demands, it is P2. For a same.
Yes.
Paragraph number 4 of my notice. It is done that in spite of repeated demands and request by applying, you have not made any efforts and not come forward to either to execute the relevant safety in favor of applying and fail to hand over the above documents to applying. No other way to go. Our client was to issue this remand notice to you. Clearly shows that readiness and willingness to remand madidru saha, he didn't come forward. That being the reason, within 7 months of execution of the agreement of sale, that is on 10/10/2013, he got issued the first notice. That notice was unserved and it was returned. That being the reason, by courier and RPAD, he issues the notice to Bangalore address, that which is served upon the defendant as such. There is no dispute. He says that he has received the notice in his evidence also.
To prove the readiness and willingness, is it sufficient to make a statement of one sentence in notice that the purchaser was ready and willing, and to repeat it in the pleading? Is this sufficient? That particularly when the defendants deny the readiness and willingness?
Sale consideration or cross examination, DW1 in this cross examination say ಒಪ್ಪಂದ ಆಗಿತ್ತು ಕ್ರಯ ಪತ್ರ ನೋಂದಣಿ ಆಗೋ ಕಾಲಕ್ಕೆ ಬಾಕಿ ಹಣ ತಗೊಳ್ತೀನಿ ಅಂತ ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ cross examination.
So what agreement says?
Agreement says that it will be paid within a period of 3 months.
Did you pay?
Within 3 months, he didn't come forward. That being the reason I could not pay him. Or Bandirda Karna Salwagi, within 7 months, I issued the legal notice on 10/10/2013.
No, within 3 months he did not come, means where it is stated that within 3 months the seller should come to you, ask you to give money, and then only you should give him money.
No, it's not so. As stated in my notice, I have made the demands.
Forget notice and evidence for a moment.
Please.
First see the agreement. Neither legal notice nor evidence cannot improve the agreement so long the agreement is clear and unambiguous. If according to you agreement is complete and unambiguous, what it says? Who should pay money to whom within what period? And is it a contingent or a undertaking simpliciter?
According to the agreement, it is said that I should pay the balance of the sale consideration.
Yes, did you pay? Have you shown within 3 months to the defendant that look here, I have 4 lakh rupees. I am coming to you today or tomorrow, whatever time you say. Come on, we will go to sub-registrar office and you execute sale.
Demand is evidence to say that there is demands made and he didn't come forward. That being the reason that I had issued the notice within 7 months.
Within 7 months, who fixed you 7 months time, sir? You have been repeatedly telling within 7 months I have issued, within 7 months I have issued. On what basis you fix that 7 months?
Time is not.
Your argument is in such a manner that 7 months is an undisputed or admitted fact. Within 7 months, you are required to do something and you have done it. Who fixed 7 months? On your own, you have taken 7 months.
What I'm trying to
And
say.
at your leisure, you have done something. And at what time you have done at your leisure, you are telling within that time I have done. Who gave you that 7 months time?
I'm not saying it's 7 months.
Then why are you repeating within 7 months time I have done, within 7 months time I have done, as though to give an impression that you are required to do that within 7 months, 7 months.
What I'm trying to say, my lord, is ಅವರು ಅರ್ಧೇ ಇರೋದ್ರಿಂದ within 7 months ಅಲ್ಲಿ ನಾನು ಟೈಮ್ ಇದು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಅಷ್ಟು ಮಾತ್ರ ಹೇಳ್ತಾರೆ ಇವತ್ತು 7 months ಟೈಮ್ ಫಿಕ್ಸ್ ಅಂತ ನಾನು ಹೇಳ್ತೇನೆ. That is not what I-
ನಿಮಗೆ ಟೈಮ್ ಇದ್ದಿದ್ದು 3 ತಿಂಗಳಲ್ವೇ? 3 ತಿಂಗಳ ಒಳಗೆ ನೀವು ಅವರಿಗೆ ಅಯ್ಯ ಮಹಾನುಭಾವ, ನನ್ನ ಹತ್ರ ಹಣ ಇದೆ, ನಾನು ರೆಡಿ ಇದ್ದೇನೆ, 2.5 ತಿಂಗಳಾಗಿದೆ, 2 ತಿಂಗಳಾಗಿದೆ, ಅಥವಾ 1.5 ತಿಂಗಳಾಗಿದೆ, ಅಥವಾ 3 ತಿಂಗಳಿಗೆ ಬರೀ 1 ವಾರ ಇದೆ. ಹಣ ತಗೊಂಡು ನೀನು ನನಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಕೊಡು ಅನ್ನುವುದನ್ನು ಯಾವ ಮೂಲಕ ತೋರಿಸಿದ್ದೀರಿ? ಹೌ ಯು ಹ್ಯಾವ್ ಶೋನ್ ಯುವರ್ ರೆಡಿನೆಸ್ ಅಂಡ್ ವಿಲ್ಲಿಂಗ್ನೆಸ್ ವಿತಿನ್ ದ ಟೈಮ್ ಅಗ್ರೀಡ್ ಫಾರ್ ದಿ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಆಫ್ ದಿ ಕಾಂಟ್ರಾಕ್ಟ್?
There is evidence to say that I requested, ಮಾತ್ರ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ, ನೀವು ಬಂದಿಲ್ಲ ಅಂತ. ಇವಾಗ ನೋಟಿಸ್ ಏನೋ within 3 months ನೋಟಿಸ್.
3 months ಒಳಗೆ ನೀವು I am ready, still another 15 days time is there, hope that you will give me an appointment of or fix a date for receipt of the balance amount and execution of the sale date. Hardly 15 days are left. ಏನಾದರೂ ಹೇಳಿದಾರೆ? ಹೇಳ್ಬೇಕಂತ ಏನು ಕಂಪಲ್ಸರಿ ಇಲ್ಲ, ಕೇಳ್ತಿದ್ದೇನೆ ನಿಮ್ಮನ್ನು ಅಷ್ಟೇ. ರೆಡಿನೆಸ್ ಅಂಡ್ ವಿಲ್ಲಿಂಗ್ನೆಸ್ ಅನ್ನೋದು
ಅವರೆಲ್ಲ ಕೇಳಿ
ಬರೀ ಒಂದು ನೋಟಿಸ್ ನಲ್ಲಿ ನಾನು ಹೇಳಿದೆ, ಕ್ಲೈಂಟ್ ನಲ್ಲಿ ನಾನು ಹೇಳಿದೆ ಸಾಲ್ದು. ಯು ಶುಡ್ ಪ್ರೂವ್ ದಟ್. The pleading itself is not the proof, you know. Pleading request to be proved. Pleading is your contention. You have taken that contention. How you prove that? How you have proved that in this regard?
Are with this one? Readings ತಕ್ಕಂಗೆ evidence, ನನ್ನ evidence, affidavit evidence ಹಾಕಿ. I filed my affidavit evidence in accordance with my pleadings. And it is not disputed that within 3 months I did not make any efforts to ಅವ್ರಿಗೆ ಹೇಳಿಲ್ಲ ಅಂತ ಅವರು ಏನು ಸಜೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ನನಗೆ. They don't suggest that ನಾನು ಅವ್ರನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂತ ನಾನು ಅವರು. That is not their case. That is not the case of the defendant, that within 3 months I did not request them to come and execute the sale deed as such.
The first instance, in his written statement, he has categorically denied, specifically denied, that you are ready and willing to perform your part of the promise, right? He has repeated your pleading in verbatim and has stated that he is specifically denying the same. We'll continue it day after tomorrow. The counsel from both sides. For the further argument of the counsel for the appellant in full. For respondent's argument followed by reply if any wish the matter.
Taken tomorrow or Monday.
It's a matter on 12/6. The top of the list. The ledger matter not reaching. Seat ತೋರಿಸಿ ಆಮೇಲೆ ಕೊಡಿ. ಅಧಿಕಾರ ಕೊಟ್ಟು ಬಂದು ಕೇಳಬೇಡಿ. Yes. 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 Make a submission in the registry. If by mistake they have posted it here, they will rectify it themselves. That means they won't post it here, they will post it before the regular thing. In spite of the same, if they shown any inclination that they would post it here for some reason, then you can make the submission. If I give a date, if I pass any such order, the registry may say you have already, the court has already heard you. Therefore, the court officer would only make an endorsement that matter was not reached today. Then you have got a better footing there to argue and convince the registry people there. Do that. Yes. Yes. Yes, please.
Serial number 18, my lord.
1 ನಿಮಿಷ 91 ಅನ್ನು. There are counsel from both sides present. Since the court term is over, the matter could not be proceeded today. List this matter any particular day you want. Yes, please. List this matter on 16/6/2023 as paid the interim order granted earlier. Is extended till then. Serial number 89. 89, yes.
The next week of the portal.
Not necessary. It will come next week. You will get it listed in next week, any day of your choice. No problem. 86, yes, please. ಅದರಲ್ಲೂ ಅಷ್ಟೇ ನಾಟ್ ರೀಚ್ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಅವ್ರು ಯಾವ್ದು ಕೇಳ್ತಾರೆ ಕೊಡಿ. ಎಸ್ ಯಾವ್ದ್ರಲ್ಲಿ ರೀ ಕೊಡಿ, ಬೇಗ ಕೊಡಿ. There are counsel from both sides present. Since the court time is over, the matter could not be listed today. List the matter the week after next. Interim order granted earlier is extended by 3 weeks from today. Yes, please. 80. Yes. Next week or week after next, whichever you want, I can give you. Next week. Other request. The counsel for apparent present, since the court term is over, matter could not be taken up. List the matter in the next week. As per. 87 ಆಗಿದೆ ಅಲ್ರಿ ಆಲ್ರೆಡಿ ಅವ್ರು ಮೂವ್ ಮಾಡಿ ತಗೊಂಡ್ರಲ್ಲ ಬೆಳಗ್ಗೆನೆ.
Serial number 88, my lords.